The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
All right, be seated, please. All right. Good morning, and the first case we'll hear today is Veteran Services versus the Union, and Mr. Duffy, we'll hear from you first.
Thank you, Your Honor. This case is about a specific limit on an arbitrator's authority, and can an employer and union combine to come together to put a specific limit on an arbitrator's authority. The limitation in question is found in the limitation section on arbitrators in our CBA, and it reads as follows. In all discipline cases, the arbitrator shall determine whether the company had a reasonable basis for concluding that the employee engaged in conduct for which he or she is being disciplined. This standard requires that the arbitrator make this determination in every discipline case, whether it's verbal warning, written warning, or discharge. Now that we've cited the standard, this court knows that your job is to determine did the arbitrator do her job by performing the mandate that she was told to do.
Counsel, does it, from my reading of that provision that you cite, it doesn't have a follow-up provision anywhere that says if you find that the employer had a reasonable basis at the time, what the consequence of that is. Does that matter?
Well, the findings are, did you violate a specific rule? We have rules that provide for immediate discharge, we have rules that provide for written warning, and we have rules that provide for verbal counseling. Her job was to make evidentiary findings using this standard and apply them to the rule she was charged with violating.
I understand. I think I understand that, but an issue is whether the failure. Yeah, I know there's a debate about whether the arbitrator, addressed that standard. Assume you're right that the arbitrator did not. That I don't see that the provision that the arbitration agreement requires you to win if there is a finding that the employer had a reasonable basis at the time. Is it your position that if the employer had a reasonable basis, you therefore win, or is it your position that she had to find that and grapple with it, and whatever the answer is, you need that first step to have happened?
That is a first step, but it's a necessary first step, because then the arbitrator must take the findings that grow out of that inquiry, and if there's a violation of the rule, she needs to determine if that violation of the rule provides just cause for discharge. But before she can apply that...
But in theory, she could say, yeah, you had a reasonable basis at the time, but based on all the evidence, I still find just cause, correct?
No.
Why is that not right?
Not for that reason. I disagree respectfully, Your Honor, with that reasoning, because what her job is to look backwards at time for what information was before the court. It's the same analysis the Misco case presented. You look back to what evidence was available at the time the discharge decision was made. If the evidence provided a reasonable basis to conclude that the person was guilty of the charge which she was offense, you would apply the charge which she was offense. It would be discharge. That's what the rules provide in this case. And rules, and then the arbitrator's decision would rest on whether or not a clearly mandated discharge in the collective bargaining agreement is just cause for discharge.
But there's a link there that you seem to be saying is required.
Yes.
There's a finding that there's a finding, if the arbitrator were to say there was a reasonable basis at the time the discharge was made, but at this point I've received evidence that showed there was no just cause. Might not have been available to him at the time.
She would not have been doing her job if she did that.
Who says, what says that?
The rule itself,
What rule?
the one I just read. In all discipline cases, the arbitrator shall determine whether the company
But shouldn't you then have, I'm sorry, sir, I didn't mean to apologize for interrupting, but shouldn't then the agreement say that if you don't do it, that means you don't, that there is cause? I mean, shouldn't it link the for cause provision to that finding if that's an absolute requirement?
Well, the arbitrator herself recognized that if there were findings of violations, they provide for automatic discharge. And they are part of the CBA. They are incorporated into the CBA, so both parties have stipulated that if a violation occurs, discharge is appropriate. And I think the arbitrator would have had very easy time saying that if the contract demands violation, if the parties agree that the person should be terminated, then that would be just cause because the employees are on notice that they can get discharged. The rule specifies specifically that they can get discharged. And so all the notice to the employee, they have copies of it because it's in the collective bargaining agreement and all those elements go into the discharge. And there should be an easy move from the violation is what's key. If she violates the rule, then the rules are in the contract.
Well, I think you're going a little bit avoiding, I think, the obvious response you have. It's paragraph 14 reserves to the employer. It says, employer reserves the right to discipline, including disciplinary suspensions, discharge or dismiss or demote an employee for just cause, which means that you have the right to do that as a matter of contract, and the union has yielded that right to you. So the only open issue on that is whether there's just cause. And the arbitration clause then submits only that issue to the arbitrator, whether you had just cause. In other words, if to answer, it would seem to me if you were answering Judge Quattlebaum in the fullest, you would say that the clause, the arbitration clause, limits the issue to whether the employer had just cause. But at that point, once that finding is made in your favor, the arbitrator's duty is over, and now you're back to the to the collective bargaining agreement, which reserves the right to you and doesn't give it's not a grievable offense if you have just cause.
Well,
in other words, the contract, the collective bargaining agreement, provides that you can discipline. It provides the remedy if there's just cause. And you have that remedy, a right to it, because it's been reserved to you explicitly. And the arbitration agreement only gives the limited issue to the arbitrator of whether you had just cause.
but Your Honor,
You fighting with me on that?
No, I don't at all. But how do you determine just cause? You
go to the arbitration. Judge Quattlebaum's question is if you succeed in arbitration and the arbitrator finds that you had just cause, his question was then, what's the consequence? And you kept trying to go to the arbitration agreement to find the answer. It seemed to me the collective bargaining agreement answers it right on its face. In paragraph 14.
I'm not arguing that. It is a just cause determination ultimately they have to make. And there are rules in the contract.
But the next
that-
question after that is, if you get the finding of just cause and the arbitrator stayed within the confines of the task given to her, what's the consequence? And your answer has to be the consequence is all she finds is just cause. She doesn't make any other determination whether the employee gets reinstated or not reinstated or whatever. That's governed by the collective bargaining agreement, which reserves that right to the company. Under
Well,
14.
The arbitrator does have a role in making the decision. She ordered back pay and reinstatement.
I thought you were arguing that was beyond the scope of the arbitration agreement.
No, sir. No, sir. I'm sorry. All I'm saying is just cause is the ultimate question that has to be answered.
It's not the ultimate question. The ultimate question is discharge. But the issue of discharge was reserved to the company and never conferred to arbitration.
Yes, sir. But in terms of what was given to the arbitrator is the standard to evaluate the conduct at the time that the decision was made to determine if there was a reasonable basis for the employer to discharge. That's what the question is. And we don't think she did it. And we don't think she did it because, as this court said in Canelton Industries, we listened to what the arbitrator did. And instead of applying the contractual standard, what the arbitrator did is apply her own standard. And it was a strict standard of proof, and it required strong, convincing evidence. And it was ultimately determined by a credibility resolution between two witnesses, which excluded what the contract said was the proper evidence to consider, which was the evidence available to the employer at the time the employer terminated. As this court in Tennecourt stated, while an arbitrator, or Tennecap, I'm sorry, while an arbitrator may use contractually delegated authority to make determinations where there are gaps in the CBA, the arbitrator cannot refuse to apply express language in a CBA dealing with the precise issue to be decided. This case is very consistent with MISCO. It was cited 5 times by the union in the briefing. But MISCO answers the same question. First of all, Justice White said you cannot ignore the plain language of the contract. Justice White distinguished between contractual directives he calls ground rules, and he gave and those matters not covered by a ground rule, which he said is left to arbitrator's discretion. And that's an important distinction. And Justice White even gave an example. He said here in MISCO, the employer forbade hearsay evidence, and the arbitrator can't use that, can't rely on hearsay evidence because it's been forbade by the parties in the contract. But on every other evidentiary matter, in this case, the arbitrator is free to use their full range of discussion. That's a critical distinction here, and it's kind of the same one this court in Tannecott used. What are the ground rules? The ground rules in doing her job was that Arbitrator Von Hoff was expected and directed and forbade from doing anything else. She had to use the reasonable standard basis in making evidentiary findings of the rule violations. That was the part of the job.
I thought your main argument, it seems to me that you're on thin ice in attacking the way the arbitrator receives evidence, excludes evidence, whether it's erroneously applies law. We've deferred to arbitrators on all of that. It seems to me your argument is the arbitrator was committed to find whether you had a just cause to terminate, and the arbitrator didn't assess that at all. The arbitrator concluded as to what happened and then ordered reinstatement.
Yes, Your Honor. I would just say that this, the contractual mandate is a pretty important ground rule. We believe the parties put it in there specifically, and so much so that we said that if you don't follow it, you can't issue a final warning.
Okay. Thank you, Mr. Duffy. Ms. Wheeler?
Thank you. May it please the court. My name is Karen Wheeler. I represent the appellee in this case, the United Steelworkers Local 7898. And as it's been pointed out, this court has been asked to vacate an arbitration award. That award was made pursuant to an agreement providing that arbitration awards are final and binding on the parties. Therefore, under the applicable standard, the only question in the case is whether the arbitrator was even arguably construing or applying the contract. And the correct way to determine whether the argument...
That's kind of, I have this sort of preliminary question, because if we
Sure.
do get to even arguably construing or the essence of the contract, that's a very high standard and arbitrators usually satisfy it. But that first question, a final and binding decision, it seems like the contract says you have a final and binding decision if the arbitrator does the things in the following paragraph. And one of those things is determine whether the employer had a reasonable basis for thinking that the conduct happened. So if we don't think the arbitrator did that, is that ground for vacating?
If you don't think that the arbitrator followed, construed the contract, then yes, that would be grounds.
Well, I mean, she construed other parts of the contract, right?
Mm-hmm.
You know, she looked at other standards and maybe, could have even reached the same outcome by construing the reasonable basis standard. But there's nothing in the arbitrator's decision that acknowledges the requirement to make a decision about whether the employer had a reasonable basis. And the contract seems to suggest that unless an arbitrator follows these particular guidelines, the decision is not final. And I'm trying to get your sense of whether it matters or whether that's somehow not a ground for vacating, or we can let this stand even though, because she construed other parts of the contract, I guess.
Mm-hmm. Well, there's two answers to that in my view. First, there are limitations in the contract on what the arbitrator can do. And in the limitations provision, it says the arbitrator shall make a particular determination, and that is exactly what she did. It says that she shall determine whether there's a reasonable basis for this misconduct finding. And the entire award...
But that's not actually what it says, I don't think. It says shall determine whether the arbitrator had a reasonable basis for its decision. And, I understand you argue that the decision the arbitrator made may have encompassed that, but it certainly never articulates it expressly. And I think there's a credible argument that the arbitrator didn't address that standard. So I think to follow up on Judge Rushing, the question is, assume, I'm not asking you to concede that point, but assume, we believe that the arbitrator did not address the reasonable basis finding requirement. Since the agreement that says this is the whole reason you go to arbitration says it's not final unless you do that, does that provide a basis for vacating the award?
Well, so I don't concede that the arbitrator failed to make that determination or failed to apply, and I can get back to explaining that. But assuming for purposes of argument that this provision was somehow passed over or not sufficiently fleshed out, not sufficiently discussed in some way, that is not a basis for vacating the arbitration award. And the reason is that the correct standard in this case is what this court has done over and over again in Technocap, that 2021 case, in MCI Constructors, in the Corvus case, which is to say that if the result that was reached, and here the result was the finding that there was a contract violation when this grievant was terminated, it did not comply with the contract, if that is rationally inferable from the contract, if it is plausible under the contract that that result would have been reached, then it should be.
About that conclusion. This is a very peculiar, I don't think I've ever seen as tightly written arbitration agreement. And the collective bargaining agreement basically says, and I haven't seen this either before, but the union has given the employer the right to make disciplinary decisions and reserve those rights, and reserve the right to have a decision to discharge somebody for good cause. And that's reserved to the company. The arbitration agreement gives that one factor to the arbitrator and no other. Not only that, it alludes in the arbitration agreement, it alludes to the court standard of finding its basis from the contract and rejects that scope. In other words, the arbitrator does not have the right under this arbitration clause to draw its essence from the agreement. It has the single issue of whether there was a reasonable basis for the discharge. The contract otherwise, the collective bargaining otherwise, takes care of what happens after the arbitrator makes that decision. Yes, there was a reasonable basis. No, there wasn't a reasonable basis. At that point, the CBA takes over. And I must say, this obviously was drafted by someone who was focusing on our jurisprudence with the generalization that usually it's a language something like any dispute arising out of this agreement or anything relating to this agreement. These are broad concepts that even the arbitrator can determine the scope of arbitrability. But in this case, they carefully reserved the disciplinary right to the employer, not to the arbitrator, and they gave the arbitrator the simple question of was there a reasonable basis for the discipline. And it seemed to me the arbitrator never made that determination. The arbitrator, to the contrary, went below that and said what happened and concluded that the person was unfairly discharged and reinstated them. Now, that's a pretty far distance from what this clause, I've never seen a clause this tight. I don't know if you have. If you have a case that shows an arbitration clause this restricted and limited, but arbitration, as you know, is grounded on contract, the scope of the contract, and we have to start with what power is given to the arbitrator. And if there's doubt about it, we defer to the arbitrator. I mean, the languages are clear throughout the cases. But maybe you can address why the arbitrator was free to go beyond that one issue.
I agree that the arbitrator's authority is limited to what is in the contract, and the contract says the functions of the arbitrator shall be to determine controversies arising out of interpretations and applications of the provisions of this agreement. So wherever there is a controversy...
Well, you can't stop there, because then it limits that, right? It limits it.
So as you observed earlier, the contract reserves the right to discipline, including suspensions,
For
discharge.
instance, it says the arbitrators may not substitute his discretion for the discretion the employer has. And of course, the very next article, the employer is given the discretion. And then it goes on, it says, any grievance involving discipline, which is here, or discharge, et cetera, for various policies, the arbitrator's sole sole authority shall be to decide whether such violation occurred. If the arbitrator finds that such violation occurred, it goes on and say, concluding the employer engaged in the conduct which he, I'm sorry, I'm not getting to the right language. It's that limitation language, though, that a reasonable basis for the discipline.
Right, and that language that you just read applies to certain kinds of cases, not this case.
It applies
So
to
drug
discipline
cases.
cases. The limitations I just read apply to discipline cases. And the discipline is addressed in the very next article.
Right. In the next article, it says, in discipline cases, the arbitrator shall determine whether AVSW had a reasonable basis.
Okay, that's the language I'm talking about.
Yes, for
That's what's
concluding-
conferred to the
yes.
arbitrator.
Indeed.
But the discipline itself is reserved. They use the word reserved. That means it's not conveyed. The union doesn't have it, and they can't grieve it. And the discretion can't be grieved. What can be grieved is whether the employer had a reasonable basis. And if the arbitrator had concluded that the employer did not have a reasonable basis, then obviously the discharge would not be allowed.
Right, and it does reserve the right to the contract does reserve the right to discipline for just cause, right? So that's a limitation on that right to discipline, and the arbitrator.
That's what's conferred to the arbitrator.
Correct, the just cause determination.
Yeah.
And in order to make that determination, we submit that the arbitrator, first of all, had to determine whether the misconduct occurred. How could there be just cause for discipline if misconduct did not occur?
It's been even narrowed because it didn't find in the actual cause in the arbitration. What's given to the arbitrator is whether the employer had a reasonable basis.
Right, so.
You find a difference between those two, don't you?
I find that they both bind the arbitrator. They are different standards, and the arbitrator has to apply both
I
of
mean,
them.
if you're going to ask whether the employer had a reasonable basis, then you would have to decide what the arbitrator had in hand, right?
Well, so the
employer
limitation on the arbitrator.
Excuse me, what the employer had in
Oh, I'm
hand.
sorry. Yes, I understood. So right, and so.
So just to make sure I'm clear, you're agreeing with Judge Niemeyer that the arbitrator was required to make a determination about whether the employer had a reasonable basis for its decision. You agree with that?
Yes, it says the arbitrator shall determine, right? And it does not say, as you pointed out earlier, what the results of that determination would be. But that determination was made in this case. The arbitrator concluded that one of the final paragraphs is there's not sufficient evidence on the record to conclude that the grievant violated this policy. So she reviewed all of the evidence and found that there was not sufficient evidence to conclude. So that is evaluating the basis for
How do we
concluding
know that's
that
what
the
she was
employee-
evaluating? We're just supposed to assume that?
Well, if you read the,
I mean, she didn't use those words anywhere. I think she quoted, if I recall, there was a citation to a provision, but there's no discussion about why or why not the company did or did not have a reasonable basis. You agree with that?
no, because I don't agree with that because the decision extensively goes into the evidence, right? It goes into
It doesn't go
testimony
into the
from.
evidence that was in the employer's hand. It went independently past the employer. So let me assume that the employer had a lot of information that had been fabricated. It wasn't consistent with what actually happened. The witnesses got together and gave the employer reports that were totally inconsistent with what happened in the plant. The employer looks at all this and assesses it and says, this is dischargeable. That's what has to be assessed, right? On the basis of what the employer had, whether the employer was reasonable. Now, obviously, if the employer didn't believe it or had no basis to believe it, that's something else.
Right,
But that's
and-
not at issue here. The question is, we have to look through the lens of the employer and see what the employer had and see whether there was a reasonable basis.
Well, that is not, that is
That's the
one
language.
interpretation of the language. That is an interpretation that, first of all, was never forwarded to the arbitrator. The arbitrator was provided with extensive testimony and argument on whether the misconduct actually occurred, and
Well,
eyewitnesses
did the arbitrator have the arbitration
testified.
agreement?
Yes, the arbitrator did.
Okay, well, that's the charter.
And, right, and so all of the parties argued to the arbitrator about whether the misconduct occurred, right? And the provision, this limitation provision says the arbitrator shall determine whether there is a reasonable basis. Now, the arbitrator, we would submit, is permitted to probe the reasonableness of that basis by soliciting testimony, by hearing testimony, by evaluating evidence on whether the misconduct actually occurred. So the arbitrator, in fact, reviewed.
It never identified the basis that the employer had. The opinion doesn't identify it anywhere.
So,
The opinion basically decided what happened.
right, and the opinion first goes into extent testimony by these employers' decision makers, right? So the testimony by a fellow named McNeil, by a person named Cooper, the HR person, the administrator, and all of the evidence that they heard. So it goes into detail on who they met with, what they reviewed, what they considered, and it then evaluates that evidence and assesses it against what came out at the hearing and what was evident to the arbitrator by evaluating the testimony of the witnesses and the available evidence. And I would just add that this interpretation of the language that the arbitrator may not consider whether misconduct actually took place appears nowhere in the contract. This is an implied prohibition, an implied standard of evidence that the employer decided, it's a post hoc, after the arbitration, to read into the contract that there's this particular order of operations that the arbitrator is tied to because of this language. This was never argued to the arbitrator at the time. And this is about the correctness of how the arbitrator assessed reasonableness.
So, counsel, I understand your argument that the arbitrator did make, reading the decision, we should conclude that the arbitrator did address this mandatory finding that you must consider whether the reasonable basis finding. But if we conclude otherwise, that the arbitrator didn't, do you agree that that we are required to vacate the award?
If you conclude otherwise, I don't agree that this court is required to vacate the award or even can vacate the award under the existing jurisprudence, because this court cannot vacate an award where there's no clearly expressed limitation that prevents the arbitrator from reaching the particular result.
But most of the, I think the cases, and correct me if I'm wrong, I certainly want to see the authority you're talking about, but I mean, there's certainly that type of language in cases. It looks to me like in MCI, for example, that dealt with the substantive issues of resolving the dispute. They go to the ultimate outcome or not. They didn't really deal with the procedural ground rules that the parties agreed must be followed. And here we're in arbitration, which, as Judge Niemeyer says, is a contractual matter. And if the contract says you got to go about this arbitration following rules 1, 2, and 3, I'm not sure there's a case that we have where the arbitrator has failed to follow those rules and we've said, hey, that's okay. What we have said is when there's different provisions substantively in terms of the outcome that weren't addressed, if we could reach the same outcome, we don't vacate. But not when you're dealing with how the arbitration is supposed to be carried out. Mm-hmm. Is there one that you can point to that deals with the procedural, the ground rules, as your colleague says, where we've made that same conclusion?
I suppose from our position, we wouldn't characterize this as a a set of rules or an order of operations that the arbitrator has to follow, simply that the arbitrator has to determine whether there was a reasonable basis. That's one determination that can form any part of the arbitrator's analysis, and I submit that that determination was made. But I think that that to the extent that the argument is that there's a provision that was ignored, or that then MCI does control and Technocap does control, and those cases do say that only, that the court can only look to whether the result was rationally inferable from the contract. And so
In that
if there...
regard, let me ask you about this limitation. This is the last sentence of the clause. And it says, the award shall be deemed not to draw its essence from the agreement and shall be vacated if those limitations weren't followed up above. It refers to limitations. It said, if you don't follow those, it says the award shall be deemed not to draw its essence from the agreement and shall be vacated. That's the parties agreed to that.
Yes.
How do we construe that?
Yes, it does. Well, I don't see that as a problem in this case, because the arbitrator did review the employer's basis for its decision and found that there was not sufficient evidence in the record.
I couldn't find that in the opinion.
Right.
Where do you think the arbitrator looked at the basis that the employer had?
In its review of the evidence, where it looks at the meetings, the employer's fact-finding process, right, where it goes into testimony by the administrator, by the HR director about the evidence that they reviewed, and then it reviews hearing testimony from the eyewitnesses and probes the reasonableness of those findings that the employer made. The employer's representatives listened, for instance, to Ms. Pangborn, who alleged that the grievance said certain things to her, right? And the representative concluded that, he made a gut determination about whether she was lying or telling the truth. So the arbitrator reviewed his explanation for why he found that, and the arbitrator then listened to Ms. Pangborn's actual testimony to probe that decision-making, to see, is there actually a reasonable basis here for listening to what Ms. Pangborn had to say and concluding that she was telling the truth and the grievant was lying. The arbitrator can do that, and she extensively did that in the decision, and then she
They allege
finished.
that not only did they not do that, but they alleged that she excluded much evidence under a hearsay rule, which was evidence of what was in the knowledge and decision-making by the employer.
Well, it's worth looking at what was excluded. I mean, there were certain...
Well, the observations of the woman coming out of the room and all upset, and 3 witnesses testifying to that, and that something dramatic happened. In other words, there was a question about who was coaching who, and who was threatening who, and none of that came in.
Well, it's not that it didn't...
And the employer yet had that information in making its judgment.
Well, she did review and refer to that evidence,
Yeah,
and just
but she
simply
didn't-
gave it less weight than that of people who actually testified, so that they could be cross-examined about the evidence that they gave to the
Well, I
employer.
thought there were about
So
3 witnesses. She didn't let any of it come in.
Right. So 2 of those witnesses gave cumulative evidence. There was a person who testified at the hearing named Graham, who was standing in that group of 3 people, right? And Graham testified and gave evidence about what Graham saw and heard at the time, evidence that the employer solicited on direct, right? So they conceded this is relevant, this hearing testimony about what Graham actually saw. Then, there were 2 other statements from witnesses who could have testified. The employer chose not to put them on. That was their choice at the arbitration to submit this out-of-court statement. That, of course, is going to be less credible because it can't be proved even for the reasonable basis determination to say, well, was this statement that you gave, what did you say to the employer? Did you write this statement under pressure? All of these go to the basis for the employer's decision.
Okay, I think you
and
have
she could
some-
not probe them. And
Yeah, I think we've gone through the red light. Why don't you continue that on the rebuttal time?
Oh, sure.
You have some rebuttal coming. Mr. Wood. Oh, no, excuse me. Excuse me. Go ahead and wind up. If you have something to wind up with, that's fine. No, excuse me, I've messed up. You don't have rebuttal. They have the rebuttal. All right, if you finished, go ahead and finish your thought there.
Sure, no problem. So to finish up that thought, the other statement that the arbitrator found was an out-of-court statement that was less reliable than statements that could be backed up by hearing testimony, that could be probed, that could be cross-examined, was by Nurse Pendarvis. But she considered those background issues that the employer found, right? She considered whether the employer had enough evidence to see that this person was disturbed coming out of the room. And she said, yes, Graham's testimony showed that. And the testimony of employer decision makers who interviewed Graham and these others showed that that's not in question. It doesn't affect the result. And these hearsay determinations are well within the arbitrators.
Well, their argument, obviously, we don't need to go too far in this because we're looking at the same document, but the issue they're saying it's not an issue of hearsay. It's what the employer had by way of information, and
Right.
and what it acted. Did it act reasonably with that information?
I would submit there would have to be an express evidentiary limitation in the contract, and this language doesn't do that. This is general
I'm
language
suggesting it
about
may
a
not even be
reasonable
hearsay.
basis.
It may not even be hearsay. It's a question of direct evidence as to about what the employer had in his hand. I mean, any executive could say, I had this, I had that, I had this, and it was all hearsay for the truth of that matter, but they acted on that evidence. But all right, thank you very much. Mr. Wheeler? You have the rebuttal. I'm sorry I transferred the rebuttal opportunity.
Thank you, Your Honor. And first, I will tell you, now that I understand your question, you were right. We do have the ultimate responsibility to make a judgment, and we have reserved that as to whether or not to apply discipline to an employee. The employer does, and we have choices in our handbook with incorporated rules. One is discharge, and we chose the discharge rule given the severity of the misconduct. It follows that the arbitrator's job was, as this court correctly pointed out, is to look back at what was in front of us at the time that we made that decision and determine if the evidence.
They argue that implicitly the arbitrator got to that because the arbitrator considered the testimony of the very witnesses, including employer witnesses who described what they experienced.
There's an easy answer that Von Hoff gave us to answer that. She said, I'm going to consider this only on the testimony of two witnesses. We obviously did not have that testimony at the time that we made the decision a year earlier. And the performance at an arbitration hearing is not what was bargained for. We were saying, look back to what the employer had at the time it made the decision, and obviously that credibility resolution was not available to us since it was a future event. So that question, she didn't look at it. She said in her own award that she was going to rely solely on the credibility resolution of two witnesses. So that was after the fact evidence. The court is right when it's asked if the determination never made a reasonable standard finding at the time of termination. We agree with that. It did not. And that evidence, even by her own admission, wasn't considered in her resolution of the issue. The court is right. The arbitrator's job is done after the reasonable basis decision is made. The level of discipline is reserved to the company. We chose the Class C rules. The Class C rules are clear. Discharge is authorized. So If we had a reasonable basis that she engaged in the misconduct, it was our job to, the discharge level was correct, and the rules provide the remedy. And then the discharge decision is ultimately tested under the for cause or proper cause. And I think
Let me ask
there's
you
one.
a question. If you applied the Class C rules and they argue that the Class B rules should have been applied, does that become a court issue or an arbitration issue?
Well, that issue was never raised.
No, it's a hypothetical.
If I was arguing the wrong rule was applied, I think
They'd have to sue for
that's
breach of contract,
substituting
right?
that's substituting the arbitrator's judgment for ours, is what I would say to that. And we reserve the right to make that determination.
But they could argue you breached the contract, couldn't they?
Pardon?
They could argue that you breached the contract.
Well, we have pretty clear rules, so I think we have to be careful in the rules.
I understand. I'm assuming they want to challenge it.
Well,
The question in this case is whether a particular issue goes to arbitration and whether the arbitrator decided it. But that necessarily leaves open contractual issues that were reserved in the CBA.
Right.
And it seems to me all the contractual issues that were not conferred to arbitration go to court.
Correct. I want to point out one case, Mountaineer Gas, for something that the union was just arguing about. It can be filtered through the through the eye of the cause provision that ultimately she has to find. And Mountaineer, the court said, look, the arbitrator had mandatory language which he ignored. He should have recognized that discharge was appropriate given what he had in front of him. And he wanted a different remedy, so he chose something less than discharge. And he did not have that option to do. Maybe this is an answer to your question. He did not have that option to do. His job was to apply the language of the CBA, and the CBA had the CBA required discharge in those circumstances.
All right.
And so he said the union's argument there doesn't work because you can't filter out, you can't get around the fact you ignored mandated language by saying, you roll that decision into the discharge, into just cause determination.
All right, thank you very much, Mr. Wheeler. We'll come down and greet counsel and then proceed on to our next case. Mr. Claybrook, when you're ready, we'll hear from you.
Thank you, Your Honor, and good morning to you all. Whether and when a child socially transitions as transgender are difficult and critically important decisions that will have repercussions for that child for the rest of the child's life. The plaintiff parents brought this case to vindicate a well-established principle that it's parents who get to make such decisions for their minor children. As the Supreme Court stated in Parham, children lack the maturity, experience, and capacity for judgment to make life's difficult decisions. The school board, though, wants to carve out an exception for the decisions of whether and when a child should socially transition as transgender. The board's transgender guidelines largely deal with how to treat students who have already transitioned. But parts of the guidelines.
Counsel, could I hate to interrupt you so early, but we got limited time, and assume for the sake of discussion, we, agree with your substantive position. Could you address standing? Could you address how parents who, from what I read in allegations, have not alleged their children or have a plan or considering a plan or transitioning, how do you have standing to challenge the policy?
Certainly, Your Honor. Yes, these plaintiff parents have standing, they have injury in fact right now.
Well, what is that injury in fact right now?
The Supreme Court in Parents Involved versus Seattle School District specified exactly what that injury is here, plus it's more, which I'll explain as well. But in the Seattle case, Parents Involved, the parents were challenging a school policy as being unconstitutional, even though it hadn't yet been applied to their children, and they knew very well in that situation whether or not it had been applied yet.
Right.
The Supreme Court said, just by virtue of being in the school district where this unconstitutional plan, allegedly unconstitutional, they found it to be unconstitutional, was in force and being enforced, they were suffering a current injury and had standing, just by the virtue of the fact that that might be applied to their children in the future.
That's probably your best case, I concede, on standing. I mean, that you do have a chain of events that has to happen there, as we have here. But it's an equal protection case. Does that make any difference?
It doesn't make any difference for standing purposes, Your Honor. And
But doesn't the Supreme Court tell us that we look at standing different depending on the theory of constitutional violation? I mean, we have different standards for First Amendment cases.
for fundamental rights cases, yes, there's, and this is a fundamental right that the parents are putting forward. And so it does demand the highest level of openness towards standing. The point I wanted to make is that our case is much stronger even than the Parents Involved versus Seattle School District case because of the secrecy aspect of this policy. Plaintiff parents want to be involved in making the decision of whether or not their child exhibits as transgender at school and when they might do that. But they don't know whether it's being applied to them right now.
How do you deal with the national security cases? Clapper with the Supreme Court, I think, and our Wikipedia case, where there's similarly hidden, information. How does that affect your claim?
I'm not really familiar with those, Your Honor, so it's hard for me to address them.
Sure.
I do think the FEC versus Aikens case, which talks about not providing information that they didn't have, so they didn't know what the story was. The Supreme Court said there was standing.
The allegation was that information existed about the candidates. True, the plaintiffs didn't have it. Here, there's no allegation, at least, that any of the parents' children, or that the school has information about the children being part of a plan that is being withheld.
That they know of.
Right.
And that takes us back to the secrecy part that we challenge in what we call the parental preclusion policy.
Right.
The secrecy policy, just by being in place, has an immediate practical effect because it creates distrust between the parents and the school, and more importantly, distrust between the parents and their children. It affects the familial relationship. So plaintiff parents want to be involved in any part of the decision of whether their child exhibits as transgender at school. So what do they do to find out whether that's happening right now? They can't ask the school. The school's policy says, we're not going to tell you if we think you might be unsupportive. And we're hiding the paperwork and special files you can't get access to. So that takes you to, okay, I'm going to ask my child when she comes home, are you exhibiting as transgender at school? Child says no. Are you telling me the truth? Or are you keeping it secret from me because you and the school think I might not be supportive? This is affecting parents right now. I think also, Your Honor, you had reference to cases that talk about constitutional violations in the standing context. A legitimate threat to a constitutional right provides standing as well. And here, that is very clear because
But hasn't the Supreme Court told us there has to be allegations that show a substantial risk, not just that there's a potential threat, but there's a substantial risk of that case? And I'm not trying to quiz you on cases that you don't address. I understand that, but the national security cases deal with surveillance of people who suspected or were concerned that they might have been surveilled. And the Supreme Court tells us that, without, pleading that they had been surveilled, that's not sufficient standing. And so it's not exactly the same, I grant you.
Yeah, and here we plead that we don't know whether it's being applied to our children or not because of the secrecy policy. And we want to be involved in the future. We don't want to be the subject of potential being kept in the dark about this. There are different articulations of the standard in this area, Your Honor, the threatened injury to a constitutional right. The latest articulation, I believe, by your court in Kinney versus Wilson lists several of them that the Supreme Court has laid out, but you have standing as long as the threatened injury is not, I'm quoting, imaginary or wholly speculative. And in this situation where the board is enforcing this policy and says it's going to continue to enforce it as new cases come about, it's certainly not wholly speculative or imaginary. It's happening right now, maybe to plaintiff parents' children. All right, if I may turn to the merits, I do want to emphasize that most of the transition guidelines of the board deal with what is happening and how to treat a child who has already transitioned. Those are not the parts that we challenge here. We're challenging the parts of the guidelines that deal with whether a child will transition in the first place. The policy requires school personnel to allow a child, upon the child's request, to use a name and gender other than those supplied to the school by the child's parents, and not to tell the parents what's going on, even to the extent of deceiving the parents about it by reverting to the child's birth name and gender and hiding those files, as I mentioned earlier.
Counsel, could I ask a question on the merits? You referred to the right of your parents to be involved in the raising of their children, and that right, and your briefs cite cases that talk about, the way the Supreme Court has described that right as fundamental, and I think that, I appreciate that argument. Here's my question. There's two questions. One is, do we look at that as the right to be involved in the upbringing of the children, or do we have to go a little more specific to what's actually factually happening here, such as the right to information from school, either about a transition matter or about important matters relating to the rearing of your children. So is it just this general right to be involved in the upbringing of your children, which is one thing, or is it to receive information from the school about that?
It's a little more specific than just the general right to receive information. It is the parent's right to make life-changing decisions for their minor children.
But wouldn't it have to be because the policy doesn't prohibit that. It might infringe on that because it keeps information from the parents. I understand that. But it seems like it might, I get the point, but I'm wondering whether it's the real thing that's at issue here is the school withholding information.
That's certainly part of it, Your Honor, and it does infringe on that constitutional right.
I've got the plan in front of me, and the part that seems to fall mostly within the fundamental right is the school says it will develop a transitional plan with the student, and it will not engage it says matters of gender identity can be complex and may involve familial conflict. And so in order to avoid that familial conflict, they'll develop a plan that the student controls whether it goes to the parents or not. The student says if the parents aren't supportive, the plan will not be shared with the parents.
Sure.
And then the plan is quite involved. It talks about half a dozen different steps that'll be taken under this transition plan.
Correct, Your
I
Honor.
gather your argument has to be that this whole process of developing a plan with the student and with not the parents is not the role of a public school or the state, but is the role of the family.
Yes, Your Honor. I hope we made that point in our briefing.
I know, but
clearly.
you are sort of talking about it's just the fact that they're excluding it from the parents. The fact is they've taken over the whole role of creating a transition plan with the student without the input of the parents.
And violating the instruction the parents have already given about what the name and gender of their child is, changing that with them.
Well, that's just part of the plan. I mean, they gender, the records, the various participants, school activities, the bathrooms, that's all discussed in the plan. The point being, though, is this is not curriculum. The point is that this is a major life decision that should involve the parents.
Exactly, Your Honor.
And the Supreme Court has said it's not the right of the student, it's the right of the parents. That's the fundamental right.
Correct, Your Honor. And just to continue on this, I want to make clear that we're not saying that every time a child has a discussion with a teacher, it has to be reported to their parents. But picking up on what you were saying, Judge Niemeyer.
Well, if it goes to medical, somebody comes in, some student comes in and says, I'm severely depressed. I can't do my work. I'm vomiting, all kinds of other things. Seems to me there is a duty at that point for the school to stay out of it and call the parents or refer the student to a counselor in the first instance and then the parents, or to notify the parents, because that whole role is a parental role. It's not the teaching, it's taking care of the child.
That's correct, and that's reinforced by Maryland statutes.
Well, but that's, let me follow up on that, because I mean, assume I agree with you and Judge Niemeyer in terms of what that is. Do we have to look, kind of following, recent Supreme Court decisions about substantive due process, do we have to ask ourselves whether the school's responsibility to provide information, like we're talking about here, or medical information, like Judge Niemeyer just used in a hypothetical, do we have to ask whether that is rooted in the history and traditions of our nation, and was in place at the time of the 14th Amendment was passed?
Well, that is certainly something you look to for fundamental rights, but the Supreme Court has already said the parent's right to control the upbringing and care and medical decisions of their minor children is rooted in those traditions.
So that's I guess I think you're right there. So that begs the question of what's the right? And if it's the right, as you describe it, it may already be established by precedent. If it's the right to get the information from the school, it may be a different question, or do you agree with me on that? Or I'm just trying to figure out how you frame the right becomes pretty important, doesn't it?
I think you're asking the question of when is it that the school has to inform the parents of what's going on. And I just want to make clear that we're not saying that every single conversation between the teacher, but when the school takes active steps, like are provided in the guidelines, to help a child transition, that is when this duty comes forward.
Seems to me that's your argument. The information business is not the right. Maybe it is a right, but the fundamental problem is the school is usurping the role of the parents in handling this whole situation. Now, what aggravates it, of course, is that they treat the child as having the fundamental right and exclude the parents. But the point is the plan actually activates a relationship between the school and the child. And there are all kinds of rules that the plan provides as to how they handle it. If they talk about counseling, they'll meet, they'll develop a plan, they'll talk about transitioning.
And the intake form, Your Honor?
Yes, an intake form.
But have to do a support scale, 1 to 10, judgment call of how supportive the parents are going to be. What supportive isn't defined, and what number you have to get in order to get
They define the
access.
privacy, all of this relationship, they define the privacy policy, saying it's controlled by the kids, and it says, may constitute confidential medical information, and disclosing this information to other students, their parents and guardians, or third parties may violate the policy. I mean, the question is, it's not just informing them about a child who said, I want to transition. It's they're taking an active role, meeting with them. It says the principal should develop a plan to ensure the student has,
Yeah,
and
that's
they
required.
talk about meeting with the students and keeping things confidential. And they're trying to obviously create a safe place for a student, but they're nurturing the child in order to allow the child to select his transition and have a plan for it without parental involvement. And
may
it's
I-
not knowledge, it's involvement.
And may I follow up on that
Yeah.
just for a moment, Your Honor?
Please.
They repeatedly try to take refuge in the guidelines saying we handle this on a case-by-case basis. But when it comes to whether a child transitions in the first place, that is decidedly not true. It's a one-size-fits-all. If a child, could be as young as 6 or 7, comes and said, I feel more like the other gender, this policy requires the school to help that child transition right then, automatically.
I know, but even if they didn't require it, they suggested or they led the child and they treated the child differently, it seems to me it's not the role of the state to get involved in gender dysphoria type of issues. It seems to me that when this arises, it's not the state that makes those decisions, it's the parents. And the problem with this plan is the state has usurped that role. The school has usurped that role. Not only usurped it, but has excluded the parents on the policy that there will be a conflict in the family. They talk about conflicting problems. And the school justifies it if the student says, my parents won't accept this, or my siblings won't accept this.
And of course, that's not an acceptable interest.
It doesn't matter.
Until-
It's the fundamental right. When we interfere and take children from the home or impose the state's requirement on top of the family's decisions, we go through a very elaborate process under the Substantive Due Process Clause. And we have to show abuse, all kinds of other things, and it's a very sensitive subject, very difficult subject. And we do remove children from homes when the unfit circumstances. But we start out with the proposition that this is a family matter for the care, custody of the family, the care of the family, and not the school. And I'll question the other side, but it seems to me the district court got off on thinking this is a curriculum issue. And I can't see anything in this policy that talks about curriculum.
All I can say is amen, and I'll save my rebuttal time.
I thought you might. All right, Mr. Schoenfeld.
Morning, Your Honor, and may it please the court. Judge Niemeyer, I want to address all of your important questions, but if I might start with standing and Judge Quattlebaum's questions. I think you framed the standing inquiry and the question exactly right here. I think Clapper controls this case and not cases like Northeast Florida and parents involved. So Clapper rejects what was the Second Circuit's objectively reasonable likelihood standard as inconsistent with controlling standing law. There needs to be a risk that's imminent and concrete. And I think all plaintiffs point to here is what they determine as an objectively reasonable likelihood. They rely on a Washington Post article that talks about 300 plans for 159,000 students.
Except the policy's in place. It's operating, and the question is who it affects.
I think-
Parents won't know.
Well, I
But
understand.
it's quite distinct from, it's quite distinct from a circumstance where the policy is deferred or only applies to one little group of students. This applies to the whole student body. It has requirements imposed on every student about not bullying, not discriminating, and it has policies about disclosures to other students and to the, not to the parents. This is not a hollow suspect. It's actually in effect, and it's actually.
So I understand the question, Judge Niemeyer, and I want to get to it because it's about how plaintiff's claim is characterized. But just to complete the thought on Clapper and go back to Judge Quattlebaum's analysis, I think, again, Clapper is precisely the circumstance that you just described, Judge Niemeyer. 1881 was in effect. The United States was surveilling, and the question was whether the plaintiffs had standing. And the court said, speculation that the petitioners would be targeted when they have no actual knowledge, that's the language of the court, that they were in fact being targeted, didn't give rise to standing. And more importantly, and I think this is where the policy and Clapper are really on all fours, is in that case, the statute, quote, at most authorized, but doesn't mandate or direct surveillance.
They
And it
don't
was-
even know whether they're being surveilled.
The same was true in Clapper,
This is
Your
the
Honor.
whole society.
Your Honor.
This is a school where they know the policy's in effect.
I understand the point, but the same was true in Clapper, right? There was a statute that allowed for targeted surveillance in certain circumstances, and the question was whether those plaintiffs, they were lawyers and human rights activists, were being targeted by the surveillance. And the Supreme Court said, look, there's no actual knowledge, there are no actual facts pled in the complaint that they are being targeted by the surveillance. And in the absence of those actual facts, there is no standing. It's not enough to say the policy exists and there's an objectively reasonable likelihood that we are going to be targeted
Maybe
by
you
it.
could distinguish parents involved.
Sure. So parents involved, I do think it's relevant that it's a race discrimination case because as I read parents involved in also Northeast Florida, those are both cases that involve competition for a limited number of spots. And what the court says in those circumstances is being required to compete amidst the imposition of an impermissible characteristic or criterion gives rise to standing. What the court rejects in those cases is a but-for element for standing. In other words, the plaintiffs in those cases didn't need to prove that but for the use of the impermissible criterion, they would gain admission to the contracting relationship in Northeast Florida or the school. But they had standing because they had to compete. They were, I think the language the court used is, they are already subject to a regime where they are competing on the basis of race. And
I wasn't sure how to read that. The court seemed to have a alternative grounds. It seemed to be saying this policy applies to all the children in this school system. It doesn't matter that it may not actually be the decisive factor, the race may not be a decisive factor that injures a particular child. So they have standing. Moreover, they say I don't know if it's exactly the word moreover, but they say some word that suggests an alternative reason, and then they explain that we've already said in previous cases that having to participate in a race-based system itself is an injury. And I know you're talking about that second one, but you're saying that that defines the entire discussion, that it's not the court wasn't recognizing two reasons why the students had standing. or
That's how
parents had
I
standing.
read it, and I also think to the extent that the suggestion is that they are students in the schools and they may be subject to the policy in the future would independently give rise to
Not subject to
standing.
the policy in the future. The policy is active and operative to every student.
Sure.
And there are various aspects of the policy that every student has to follow.
So-
And it has an open invitation encouraging any student who feels some sense of dysphoria to get engaged in this activity with the school without the parents involved.
So and I'm happy to come back to the standing question, but
No,
just,
I understand,
want
but I
to,
just want to.
No,
It's not a hypothetical policy, it's actually being engaged in, and it has aspects of it that are applied to all students on a current basis.
so with respect, Your Honor, I don't think that is what the plaintiffs are challenging in this case. The briefs before this court and the complaint are very specific, that they are challenging what they call the parental preclusion policy. That's it. In fact, in their reply brief, they say explicitly they fault us for defending the guidelines writ large as opposed to addressing specifically the parental preclusion policy. I don't read the plaintiffs in this case to challenge the entire construct of the policy, which allows for.
And they don't purport to, but what they do challenge is the usurping of the parental role.
But if that's right, then they don't have standing. I mean, I agree with you.
Well, sure they do.
I understand that we may disagree on this point.
No, the school says anybody in this school who senses that they may have some sense of dysphoria, we're not comfortable with your gender, you can file an application and we'll engage in a private relationship and create a plan for you without your parents knowing. Now, it seems to me that, I don't care how you characterize it, that plan is operative, that invitation is open, that the student can be encouraged when otherwise would not be encouraged to do something that the parents would not agree with.
So I
So they
disagree.
exclude the parents in order, which is also part of the policy, to exclude the parents in order to encourage the students to get this separation, conflict with parents, as the policy talks about.
So I disagree with your characterization, and I'm happy to address that in a
Well, every
moment.
one
But
of them
if
comes right out of the policy.
I understand that, but if your point is that what is present right now is an invitation to engage with the school, I don't think an invitation gives rise to any standing. There's no constitutional right or any right.
Don't parse it. Let's talk about the whole policy. It goes from, it's several pages.
But I think I need to parse it because I need to identify what their injury is. So what is their injury?
Is basically interfering with the parental right, the fundamental right, probably one of our most fundamental rights. The Supreme Court goes out of its way to talk about how fundamental this right is in history and throughout our jurisprudence. We don't usurp the family role, and the school is trying to step in the shoes of the family and create transitional plans, encourage the child, help the child, keep information secret, change pronouns, change the activities, the roles of the activities in the various activities in the school, all without the input of the parents.
So
Now, I don't think the input of the parents saves the game myself. I think it's the displacement of the parental right. It's not an educational right.
I understand your view of the policy for sure. There's no allegation of interference and there's no allegation of displacement in this case by these plaintiffs.
If you go ahead, sure.
If you go ahead, right. I think that's the issue. There is no allegation that right now these parents
They
are being
say that
affected.
They're talking about gender identity may involve familial conflict. That justifies their keeping the family out. They say that again and again, that type of thing, but here they actually use familial conflict. So the policy is trying to avoid familial conflict over gender. Now tell me where the state gets the right to address that issue at all.
I'll answer your question. I want to answer it dead on, but just to tie it back and maybe finish up the circle on standing, There is no allegation that any of the rights that you've just described, and I disagree with you that those are rights that exist or rights that are interfered with. There is no allegation of interference of those rights by these plaintiffs. The only allegation is that they are among the parents of the 159,000 students in the schools. Their injury needs to be individualized and not generalized, and it needs to be imminent and concrete.
Why isn't to compare this to the national security cases, there isn't this, allegation. I think the parents have, pled, that the policy does the things Judge Niemeyer's talking about, and to every student, it creates almost an invitation to participate in this. Now, I get the point that there's not an allegation that that's happened with their children yet. But does the fact that the policy, at least as alleged and maybe as written, invites that type of activity, distinguish this from the cases in Clapper?
I don't think so. So first off, in Clapper, I think that allegation was made, right? The allegation was, we are retreating from our zealous representation of our clients because of fear of surveillance, and the court said that that wasn't enough.
That's you're right. A choice to do, that's the different point. The point is, right now, every student in Montgomery County, there's an allegation that the policy, it maybe is an invitation or encouragement.
Yeah, there's no allegation to that effect. There's no allegation that they are being encouraged to do anything. The allegation is that in certain circumstances where through this student-led process, a student devises a transition plan, information is being kept from the parents.
I think that the allegations reasonably imply that. Is that, or hypothetically assume we had that allegation?
I don't think so. There still needs to be an allegation.
I didn't get a question out.
Oh,
What do
sorry.
you not think? So I'm
Sorry.
teasing. I think you know where I'm going, which is, why wouldn't that make a difference?
I should have let you complete
No,
the thought.
don't
I
worry.
apologize. I still don't think it would make a difference because there still has to be an allegation of an injury in fact. If their allegation, for example, was, we're being alienated from our children because of the existence of this possibility, and there is actual concrete facts that they could plead that they're being alienated from their child. They don't allege they've discussed the policy with their children. They don't allege that they've discussed the question of gender transition and the existence of this policy is having an effect on the way that they present those issues to their kids.
Would you agree they're standing if they said, look, the state has no business doing that, the school district has no business doing that, so now I have to go in and start talking about gender identity issues, way earlier than I think is appropriate as a parent. And that's directly affecting my ability to parent.
If they could plausibly allege that they are having conversations with their children sooner than they otherwise would at younger ages, because otherwise these issues are going to be introduced to them in school, maybe they could allege Article 3 standing. I still think that the claim fails, but I think under those circumstances, if it were a less attenuated chain of events, then potentially there's Article 3 standing. But again, to go back to Judge Niemeyer's characterization of their claims, I read their complaint and their briefs in this court to be explicit that they are challenging the parental preclusion policy, and they've never deviated from that characterization.
That's part of the policy. That's the part they're offended with. In other words,
That's the part they're challenging.
if they were known about it, they could object, withdraw their child from the school, do whatever they wish. But the basic problem is they allege they're kept in the dark.
Well, they know about the policy. So if their theory is, if they're so offended by the existence of the policy,
That's what they're challenging.
but then they can move their kids to a different school, right? If the theory is that we have the right to direct.
But that doesn't mean they're not being injured. In other words, I believe that the very establishment of this relationship between the school and the students under this policy is in and of itself inherently interfering with the parental rights.
I understand your position, and I understand
I'm
the way.
just saying whether we engage the fundamental right under the Constitution. Now, whether they articulate each legal reason, they have challenged this policy as an interference with their parental rights.
I believe that
you're saying, since their child isn't transitioning, of course, they don't know that, but their child hasn't invoked the policy, and they don't know whether that's so, they can't sue. And my suggestion is that when we have the policy in place conceitedly, the policy tells students how to accommodate transgender. It invites students to participate in the program. It invites them to do a plan. It allows them to exclude their parents. It justifies it on the fundamental right of the child, not the parent, and it and recognizes that there'll be parental conflict.
So I think all of the things that you've just listed as features of the policy are not ones that they challenge. The only thing I understand them to challenge, and again, they're quite specific about this, is what they call the parental preclusion policy, which is in particular circumstances where a student
Isn't that just a gate to the whole thing?
I don't think so. I mean, if what they object to is the policy and their submission to the court is, I have a right to direct the upbringing of my child, and the existence of this policy is interfering in it because of, as you describe it, Judge Niemeyer, there's an open invitation. What the Supreme Court recognized in Meyer and
Here's
Pearson—
an allegation. It says, issues regarding whether and how children perform a gender transformation are of fundamental importance, and their improper handling could have long-lasting negative ramifications for a child's physical, mental, and spiritual well-being. That's an allegation.
So I read that to be in the service of a claim that they're entitled to information about that. I think, I would point the court to the
I think
opening—
you're splitting hairs. It seems to me their whole purpose here is to challenge this policy.
Well, so I'm happy to defend the policy on the merits. I respectfully disagree with you. I think the challenge is somewhat narrower. But with respect to the merits question, again, Judge Niemeyer, to go to your set of claims, there are plenty of cases that deal with intimate matters addressed at schools and other public facilities for minors, where the court has considered precisely the question you're positing, which is, does the provision of counseling and pastoral care to a student or a minor contravene a parent's right under Troxel and other cases to direct the upbringing of the child? There's not a single case that concludes that way. Anspach in the Third Circuit, Arnold in the 11th Circuit, Reardon in the Eastern District of Michigan, the Sixth Circuit's in bank decision in Doe versus Irwin, all of them address questions of the utmost intimacy for a minor, and all of them say there is no obligation to inform parents about these decisions, and the only place where—
But that's not, the informing is not the point, right? They're complaining about informing the parents because it's the parents' decision to make, right? And this policy says the school will decide to transition the child, and we won't tell the parents and let them decide because we think they would disagree with the state's decision.
So I disagree with your characterization of the policy, and I think it's a critical one. All of those cases, by the way, address the informational piece, but they all hold that there's no violation of the parent's fundamental right by helping the child procure an abortion, helping the child procure emergency contraception, alienating the child's affections from the parent because they're dating a particular person the parent disapproves of. But Judge Rushing, to go to your point, there's no allegation in the complaint, and there's nothing on the face of the policy that says that the school is making any of the decisions here or directing the process. There's no coercion. There's nothing prescriptive.
Who's deciding?
The child is deciding. The policy makes clear—
The Supreme Court has told us, right, that minors aren't capable of making substantial life decisions, that someone decides for them, someone counsels them, and the fundamental right to make that decision for a minor belongs to the parents. The Supreme Court has told us that. And so at least they have alleged, right? The question here is only have they alleged that that fundamental right has been infringed when the school says, we think the parents will disagree with this decision, so we won't tell them.
So I don't think it's when— I think it's when the child says that they're entitled to some privacy and don't want to disclose the information
This
to their
policy
parents.
applies to 6-year-olds and 5-year-olds, doesn't it?
I think it applies to all students in the school. It's not an as-applied challenge, it's a facial challenge. And so they need to demonstrate that it's unconstitutional in all its applications in order to prevail here. This is not a case where the school is saying that in particular circumstances, a particularly young child was subject to the compulsion.
Right, but the force of Supreme Court precedent is against you when you say this is the minor's right.
So
the
I'm
minor
not sure
is
what,
choosing.
yeah, I'm not sure what specific line of cases you're talking about, but in the abortion context, the court recognized that minors have the right to obtain an abortion. Obviously, this was pre-Dobbs. And under certain circumstances, the state could impose particular requirements for parental notification or parental consent under particular circumstances, but it recognizes that minors have a right to privacy in making intimate choices. The constitutional right is the right to, or was the right to obtain an abortion, and minors had that right just as people who were not minors had that right. When you're talking about in a school setting how the school is going to go about counseling a child who presents with a particular set of issues, it has always been the case that schools are able to provide that sort of counseling. And there's no allegation here, as in the cases like Arnold and others, where there was a real set of allegations, or Gruen in the Third Circuit, that school personnel crossed the line by coercing students, imposing their will. In Arnold, the school forced the child to get an abortion against her will, forced her to work menial jobs in the school against her will to pay for the abortion. And that was where the court said, look, counseling a student is permissible. Kids present with all sorts of issues in schools, and schools need to be able to handle it. And
But
schools,
here the allegation is, this policy says we will not tell the parents a decision about the upbringing of their child because we think the parents will disagree with it.
so
That's the policy.
right. And so, again, I don't mean to split hairs here, but I think it is important that in those circumstances, the student is saying that right now, I want this information to be kept confidential from my parents.
You got, I mean, that, maybe that has two problems. I mean, first of all, the problem Judge Rushing's talking about minor children making decisions on that. That, I mean, I hear that you have some, pre-Dobbs cases where, facilities, where medical facilities don't have to turn over information. But for schools, to engage in this role, I mean, in the policy, it seems, I don't see how you can, walk away from the fact that, the policy clearly says they're not going to provide the information if they deem the parents are not supportive. And I mean, just think of what that means. I mean, that's one of the most broad things that the parents might be not supportive in as a basis. I mean, I get the standing issue, but to somehow, say that this is, not a decision, that keeps, the most fundamental decisions out of the parents' hands and into the school, I just think you're ignoring the plain language of the policy. I think if they're standing, I mean, this is as fundamental as it gets. If it's standings might be a challenge.
So I think, respectfully, I disagree with you, and I think the cases that I've discussed all speak to that, and I don't think they turn on the fundamental right to obtain an abortion. I think they all address this issue in the same line of cases that plaintiffs are pointing to, Meyer, Pierce, and Troxel. In those cases, the same allegation was made. Public officials, school officials, officials at public health centers are arrogating to themselves the role that is traditionally reserved to parents. They are doing it by facilitating a child from getting an abortion, facilitating a child from obtaining the morning after pill. I think things relating to sexual abuse or assault, all of those things that go to the heart of what a parent wants to know about their kid and wants to handle. All of the courts rejected the sort of Meyer-Pierce substantive claim and said, and I think the language of Ansbach is particularly helpful here. This is the Third Circuit's decision. It says, the real problem alleged by plaintiffs is not that the state actors interfered with the Ansbachs as parents. Rather, it's that the state actors did not assist the Ansbachs as parents or affirmatively foster the parent-child relationship. Here, for the same reasons, there's no interference with what the parents do. The parents are free to do whatever they want at home to counsel their kids.
That's the whole point. The whole point is that the school is displacing the parent. They're not telling them because they don't want the parent. They don't want the parents to interfere. Right? The school is not telling the parents because they don't want the parents involved. It's not as though, sure, I understand your point that the parents can talk to their kids about gender transition and transgender issues till they're blue in the face, right? The parents can talk all day about it. But if the parents aren't told that a decision to transition their child is being made, they can't be a part of the decision, right?
So if you're right that that is the gravamen of the claim, then the question, and I think this goes back to Judge Quattlebaum's question about the level of specificity of the right we're talking about here. If that's the gravamen of the claim, and that's how I understand it as well, then the question is whether parents have an affirmative constitutional right to disclosure by a school about these issues, and there is no such right.
No, it's not it's, do they have a right to the school not to hide it from them, right? For the school not to hide the fact that a decision is being made, right?
Even if that's right, I still think there's no affirmative constitutional right to that. Look, as a matter of common sense, as a matter of democratic legitimacy for school boards across the country, they may decide something different from what Montgomery County has decided. As a matter of constitutional law, however, there is no affirmative obligation on a school board to disclose that sort of information to parents.
To tell parents that the state is arrogating to itself the right to make decisions about your child's gender.
The policy is not secret. Everyone knows what the policy is. The question is if in a particular case, a student tells a school teacher that they want to transition at school and that they don't want to disclose that information right now to their parents, in a policy that, number one, has as its end goal the integration of families into this discussion, and number two, is subject to constant revision and consultation with the student. If in those circumstances, the school decides in concert and in furtherance of the student's wishes that it's not going to disclose that information at that point in time, there is no constitutional right to the contrary. There are lots of circumstances, and we point to the Maryland state law on all of these. In cases of abuse, in cases where a student is dealing with an abortion or a pregnancy, and in cases where a student is dealing with issues related to drug addiction and the desire to overcome drug addiction. Maryland state law doesn't allow a school to disclose that information to a parent unless the student consents. This is no different. And the school has the discretion to formulate that policy. Obviously, schools are free to formulate different policies. But the question here is, are you going to constitutionalize the obligation of a school to provide this information?
No, you keep putting it flip thing. What you're doing is you're concealing it. You are usurping the care and custody of the children, which is, it is not curricula, it is counseling and helping a child transition without the parent's involvement. This is a family decision.
So
and it falls within the fundamental process recognized for centuries. And it seems to me that it's not a question of affirmatively disclosing, it's a question of concealing.
So if that is correct, and I hate to
I don't think that solves the problem. But that's the gate to the problem. In other words, the problem is the role of the state in promoting transition of children. They're supposed to be teaching children. They're not supposed to be engaged in the transition of gender.
So a couple of thoughts. The first one is with respect to the concealment, I think, again, not to sound like a broken record here, but that really does underscore the standing deficiency, right? There's no allegation that anything has been concealed from these parents, or any parents. There's no allegation.
Sure there is. The whole policy has it built into it. And there's no suggestion that the policy is not being followed. As a matter of fact, there's allegations that the policy is in effect.
There are allegations that the policy is in effect. The Washington Post article they refer to.
Well, I don't need the policy.
Isn't the I mean, I don't, if they had asked, if they allege they've asked for the information, and we're not going to tell you, I mean, isn't that an allegation of concealment that's happened right now?
So there is no such allegation. They've never said they asked anything about any of their kids.
I didn't ask that. I said,
yeah, no, I understand. So if they made an allegation, I mean, we don't know what would happen, right? We don't know if they went to the school and they said.
Right then, you're saying, look, I want to know, parent at school, this is important to me as a parent. I want this to be my decision with all due respect and not yours. And so I want to know if there's ever any, inquiry from my student, ever anything at all, will you commit to me to tell me that? And the school says we can't do it. We have a policy that says if we determine it might be, you might not be supportive, we're not going to tell you. So we can't say in advance. is that, enough right then that, that they've been told affirmatively that it's going to be concealed?
I'm not sure, but I don't mean to fight the hypothetical here. I don't know the answer to your hypothetical, but what I will say is, it is not the case that with every gender transition plan, information is being concealed from the parent.
Right.
And so the answer to the question very well may be, I'm teaching Alan, I know him well, I'll have a discussion with him and I'll talk to him. And if he devises a gender transition plan at school, we'll have a discussion about it. And if he tells me that right now he doesn't want to disclose that information to his family, he wants it to happen in a month or 2 months from now, I'll honor that request to keep that information confidential for a time. That is what schools have been doing with respect to all sorts of existential issues for students.
Can we infer from the allegations of the complaint about the policy that if a parent has to call the school and ask whether their child has one of these plans, then the school will say, we can't tell you, right?
I don't think that's a fair inference.
Well, let me explain my thinking here, that the policy says that if a parent is supportive, we're going to include them in devising the plan and so forth. So if a plan existed and a parent were supportive, they would know about it already. So if they have to ask the question, then the response is either, yes, your child has a plan and we're not going to tell you, or no, they don't have a plan. But you have to say the answer in both of those situations from the school has to be, we can't tell you.
I think the answer could also be, you should talk to your kid.
Right, which is, we're not going to tell you, talk to your 5-year-old.
Sure, again, I don't.
Well, the plan has that explicitly in there. The plan has a section called Privacy and Disclosure of Information. And it says basically it cannot be disclosed to the parents. And it says the fact that students choose to disclose their status to staff members or other students does not authorize school or staff members to disclose a student's status to others, including parents, guardians, and other school staff members. And higher up, it says that this information is confidential even from parents.
That's not how I read that language. I think that when the student...
Well, I was reading the language.
No, I understand that, but when the student provides consent to share this information with the parents, obviously it can be disclosed to the parents.
Disclosing this information to other students, their parents/guardians, or third parties may violate privacy laws such as the Family Education Act, so forth.
Right. I read their parents, guardians to modify other students, which is the immediate preceding phrase. So what it's saying there is that FERPA prohibits the disclosure of a kid's transition.
That's absurd. Nobody cares about the other students' parents. It's the student involved.
No. So I read that language there to say disclosing this information about a student's gender transition to other students violates FERPA. Disclosing that information to other students' parents or guardians also violates FERPA. Students are entitled to some privacy, including with respect to issues related to gender transition. And all this policy says is that it's going to respect the student's wishes about who gets to know this information. And so in order for there to be something wrong with that policy, the parents need to identify a substantive due process protected right that gives them an affirmative right to that information, or, Judge Niemeyer, an affirmative right. I understand your point that it's not about not disclosing the information.
You keep focusing on an affirmative right to disclose. That's not even alleged in the complaint. The complaint is it's being kept secret. But setting that all aside, you've got to understand that this plan authorizes and encourages the development of a transitional plan with actual transition without the engagement of the parents. Now, the question is this something the school ought to be doing?
So I think that the case law supports
I understand
schools.
you say because they've supported an abortion in one state and another place.
No, I think what those cases recognize is that, and I think this goes to another one of your questions, and I also realize I'm way over time, so please cut me off whenever. Judge Niemeyer, I think this goes to another sort of series of questions you raised, which is about what is the proper office of a school. And I think it goes beyond curriculum, and I think the district court's decision recognizes that. But there's a line of cases that addresses things that go from curriculum to compulsory community service, as in this court's in Herndon, to mandatory condom distribution, in the Massachusetts Supreme Judicial Court's decision and Alfonso in the New York Appellate Division. I think everyone recognizes that schools do things that go beyond the strict curriculum of the school. And the same line of cases applies to all of those. Where courts have drawn the line between permissible provision of educational services, which includes counseling, and I think the courts have been really explicit to call out that schools are entitled to provide counseling, and limitations on what schools can counsel on are a matter of democratically enacted policies, school board policies and constitutional policies. Where schools cross the line is where schools impose their will to the exclusion of the parents, where they coerce or manipulate. And there is no allegation that anyone in Montgomery County has ever coerced or manipulated a student into an outcome that the student
So
did
you
not
have an
himself.
11-year-old student making a decision, a life decision, without, with the guidance of the state and not the guidance of the parents.
I think
That's what it comes down to.
So I think it comes down to a student presenting at school with a particular set of issues or concerns, and the school trying to provide support for that, even if that means for a
More
time.
than support, more than support. Actually adopting a transition plan.
Well, I think the transition plan is meant to provide support. I mean, if a kid.
No, it accomplishes a transition that the parents have not participated in.
I think it's a way of reflecting a transition. We don't know what the parents have participated in. If a kid comes to school and says, I don't feel.
I don't tell my parents, and I know my parents won't like it, so don't tell them. And the school says, fine.
I think as a matter of school board policy, the school is entitled to enact that policy, and the question is whether
Okay,
parents.
that's the issue in this case.
Right, and I think the question is.
But the difficulty, and my pushing back is that we need to face the issue head on. We don't need to look at collateral issues that this is a obligation to inform parents, or this is a counseling issue. That this is a plan to adopt a transitional, transgender plan to a young student, and at any age from 11, 15, and of course during that period, the science shows that people's gender likes and dislikes and functioning change a lot. And so the school's making that decision with the child, and the parents are being left out.
I understand, Your Honor. With respect, I've been litigating this case for 3 years. That's never been the way this case is framed. I don't read this to be a challenge to the school's ability or power to adopt this kind of policy. I read it to be a challenge to the existence of a provision that keeps certain information from the parents confidential at the student's wishes. So I think it is a narrower challenge. I understand completely that the two issues are related. And where I see the connective tissue is where the parents say, I need that information in order to be able to exercise my fundamental right under Troxel and other cases. But I have always read this case to be a
Says
challenge.
Montgomery County Board of Education, this is the complaint, has violated these rights, fundamental rights, by adopting a policy expressly designed to circumvent parental involvement in a pivotal decision affecting the plaintiff's parents' minor children, care, health, education, and future.
And I read the circumvent.
That's their allegation in the complaint. And the cabinet too far is just being unfair.
I hear you, Your Honor. I think it is a fair characterization of the complaint, including that allegation, that it challenges the confidentiality provision. Because the whole notion of circumventing parental rights is that parents are excluded from it. This is not a challenge. I mean, if you had a circumstance where a parent was involved but still disagreed with the school about what was happening, that would be a very different challenge, and that's not the challenge
policy
here.
doesn't include that possibility. The policy anticipates parental conflict and therefore excludes the parent from the conflict when the family conflict should be relegated to the family to solve.
So that's not how I read that language. I read that language to acknowledge that there may be circumstances of parental conflict, in which case the student may make the decision to keep the information
Well, if the
confidential.
student works with the parents and tells my parents, today I was at school and I signed a form, and the parents say, well, let's look at it and so forth, that's not what we're talking about. What we're talking about is the policy as written, which gives the student the decision-making to keep the parents out of the whole process.
Exactly, and I think that's the aspect of the policy that they facially challenge. I think that it is fundamental to their entire characterization of the policy and all of their legal arguments that information is not being kept. I don't read this, and then I'll stop talking and sit
Well,
down.
I think we're
Okay.
through the
Understood.
red light here. And, let's get back to Mr. Claybrook.
Thank you, Your Honor. Just a couple bullet points. First, on standing, I just would remind the court that the procedural posture of this case is on a motion to dismiss the complaint, and the Supreme Court in Lujan said that general allegations will suffice to support standing in that situation, with the assumption that specific allegations can be proven up later with specifics. But in addition to the paragraph that Judge Niemeyer, you've been citing during your questioning, I'd direct the court to paragraphs 1, 2, and 33 through 43, where we talk about irreparable injury that's occurring right now to these parents. With respect to the curricular exception, I just would make the quick point that that exception has never been stretched so far by any court as to say that schools have the right to keep things secret from the parents about what's going on at
I'm
school.
puzzled by your constant emphasis on the keeping secrecy. You make it sound as if that's the centerpiece of your claim. And it seems to me that when you read these Supreme Court cases and our cases talking about the substantive due process right, it's the right for the care or custody of children that the parents have. It's a fundamental right. We're not talking about, we're talking about something where we've made exceptions to procedural rights and enforcing long-standing substantive rights. And you'd allege them in your complaint, but then you keep emphasizing, well, the problem is they didn't tell us. Well, sure they didn't tell us. They're hiding it because that's part of the policy. But the policy is they're substituting their judgment and their treatment and their engagement in the child in a transition process, and they're substituting themselves in lieu of the parents, and to keep the parents out, they don't inform the parents that the child doesn't want it.
That's exactly right. And let me close with that, some comments about that. Under this policy, if a child as young as 6 or 7 says that they feel more like the other gender, school personnel are required to help them make that transition. But not all 6-year-olds or 7-year-olds or 17-year-olds for that matter are the same. Each is unique with unique needs that the parents know best, not the child and not the state officials. And this is not just common sense and conventional wisdom. It's required as an assumption, as a matter of law, that parents have the best interests of their children at heart. Now, the assumption on which the parental preclusion policy is based, that children always know what's best for themselves when it comes to sexual matters, is not just wrong-headed, it's dangerous for children. As Dr. Anderson in her amicus brief points out, for exactly this situation. The Supreme Court explained in Parham, in words that could easily have been penned for the parental preclusion policy, that the fact that the decision of parents, and now I'm quoting, is not agreeable to a child or involves risks, does not diminish the parent's authority to decide what is best for the child, or automatically transfer the power to make that decision from the parents to some agency or officer of the state. The parental preclusion policy is designed to allow a school to circumvent the parent-child relationship. And it invariably does damage to that relationship when a teacher or counselor asks a child, "Can you really trust your parents about this?" Or when a parent has to ask a child, "Tell me the truth, are you lying to me about whether you are exhibiting as transgender at school?" The judgment of the district court should be reversed. Thank you, Your Honors.
Thank you. I think we take a little break. We're going to come down and take a recess and come down and greet counsel.
This honorable court will take a brief recess.
do we have everybody?
I think one of them's.
You're still waiting for somebody? Okay, that's fine.
There was a little bit of line in the ladies' room.
No, that's all right, that's all right. I know the trains have to go on time, but we don't. Catch your breath? Yes, sir. All right. We'll proceed with United States versus Campbell, and Mr. Nettles, we'll hear from you first.
Good morning, and may it please the court, counsel. Today, the court wrestles with the question of whether or not the district court sentence in this revocation proceeding was plainly unreasonable. In order to answer that question, this court has to first determine whether or not the defendant's admitted conduct of the South Carolina state law offense of attempted robbery is a crime of violence under the United States Sentencing Commission guidelines. As this court is well aware from many cases dealing with the guidelines, there are two prongs to whether or not this offense is a crime of violence. The first would be the force clause. I think it's noteworthy in this particular case that the government does not defend this case as a crime of violence under the force clause. They have not raised that in their briefs at all. Briefly, Your Honor, I will touch on it. In the past, prior to June of 2022, there was a difference of opinion as to how, in the courts as to how the force guideline was to be construed. We now have an answer from the Supreme Court. The Supreme Court has held in Taylor back in June of 2022 that the force clause covers only offenses whose elements involve force, the use, attempted use, or threatened use of force. And it's clear, based on Taylor, that the South Carolina offense of attempted armed robbery does not involve the use, attempted use, or threatened use of force due to the overt act element that's attendant to that offense. So that being said, unless the court has any questions in regard to the force clause, I'll move to the residual clause. This case sort of puts me in a strange position. The government has taken the position that the residual clause is vague. I'm not going to be a lawyer who stands up here and tells the court that the residual clause is not vague. It is vague. But I think that the court needs to understand that you have the force clause, then you go to the next subsection, which includes enumerated offenses, and then it includes the residual clause. Based on Kaiser and this court's opinion in Campbell, the enumerated offenses in the commentary expand the enumerated offenses in the guideline. And under Campbell, that expansion of the scope of the number of enumerated offenses is clearly inconsistent with the text of the guideline.
It is, counsel, I mean, I'm familiar with the Campbell, other Campbells, kind of get confused talking about Campbell here, but Campbell discusses how the attempted controlled substance offense would be inconsistent because there's in 2B a long definition of that. Crime of violence is not quite the same, and I can appreciate the argument that it might be inconsistent, but doesn't the residual clause itself make the crime of violence distinguishable from our prior Campbell case? I mean, that language seems to broaden things to create a situation that isn't as directly contravened by the definition as you had in the controlled substance.
And you're talking about the enumerated offense clause and the residual clause specifically?
Yes, sir. Yeah.
Why, I would answer your question by saying that the enumerated offenses are offenses placed in there by the commission. There are 4 of them, and they
Right.
chose which ones to put in there. And by choosing to include some in there, they chose not to include others. And they put those in the commentary.
Correct.
And so based on that teaching from Campbell,
Well, what about just the residual clause itself?
That's what.
let me,
Residual clause itself seems to be broad enough to cover, we're talking about, aren't we talking about attempted armed robbery?
yes, Your Honor, we are. We are.
Why doesn't the residual clause itself cover that?
I'll address that question. Can I make one point before I address that question, Your Honor? We contend in this particular case that the government did not argue the residual clause in the district court below.
I understand that you had Johnson facing you and you didn't have Beckles.
That's correct. That's correct.
And Beckles came the year later, but.
That's a fair assessment, Your Honor.
yeah.
So the argument as to whether or not attempted armed robbery on the merits with a risk analysis that you have to do under the residual clause that the courts have done, that the offense has to be violent, purposeful, and aggressive. You have to look to the elements of the South Carolina offense. And in the elements of the South Carolina offense do not necessarily present an offense where there's a serious risk of potential
But
physical injury, and I'll explain why,
Okay, go ahead.
if I can.
Yeah.
So, as this court is aware, the South Carolina offense of attempted armed robbery has an overt act element. And the overt act element is to be liberally construed. It's fact-dependent. And the court has said that in the overt act scenario, the overt act does not have to be the last proximate step before the completion of the offense. It just has to be a step after the preparations have been made. And you have South Carolina cases. You have the Green case, for instance, which was an attempted criminal sexual conduct where the defendant in that case had online communication with what he thought was a minor, and then arranged a meeting with that minor for the purpose of having sexual relations. The court said that that conversation on the phone, that orchestration of the meeting itself was the overt act.
But counsel, I mean, so just, it seems to that's, I appreciate that. I'm trying to figure out how we look at this issue. And it seems to me there's 3 ways that you have to prevail on 3 different avenues, if you will, for finding that it's a crime of violence. One is whether we can look at the application notes.
That's
correct. I know your argument is that prior Campbell controls that, but as Judge Niemeyer said, perhaps the residual clause is broad enough that Campbell doesn't control and it fits there. So that's one. Number 2 is just our precedent. I mean, when you look at our doctor case, that admittedly was under the force clause combined with MAC, which says if you meet the force clause, you're going to meet the residual. You got our precedent there. And then the third is what you're kind of talking about now, I think, a traditional ordinary use sort of claim. And I get your argument that there's cases that might, not involve, violent things. But our question is, not it's not, like it is, look for the least violent way. We look to what the ordinary way is. And, so I don't know that finding a case is as helpful as looking at it from the ordinary way. Or maybe I'm looking at that wrong, but.
Well, as I understand that, and I may have it wrong, Your Honor,
Yeah.
and as I understand it, in order to prevail in a lot of these cases previously, prior to Taylor, the defendant couldn't just present some hypothetical as to how the elements interacted he had to actually show a case that.
Well, in this case, that raises a question. I hesitate to raise it because it gets pretty involved, but the revocation language doesn't focus on a conviction it focuses on conduct.
Yes.
And so it says the actual conduct involved in the revocation, and of course, in this case, he had the gun, pointed the gun, and attempted to rob, and then ended up shooting him in the legs and hitting him with the bullets. So what does the role of the word conduct play? It says conduct that constitutes a crime of violence under federal or state law.
Yes, Your Honor, I understand that to mean elements, that the conduct involves an offense which has elements that are by their nature, present a serious potential risk of harm.
What's the actual language say? Conduct that constitutes?
Yeah, it does say conduct, it does say conduct, Your Honor, that's correct.
And how are we supposed to handle that?
I don't,
I mean, it serves a little bit like the Shepard documents, it gives us a little more information as to how the statute was violated. Clearly, the conduct in this case, under anybody's standard, would be violent. But the question is whether the statute restricts us to make that obvious conclusion.
well, it's a new law violation. And this court has held repeatedly that in these supervised release violation hearings, you have to apply the categorical approach. And the only way to apply the categorical approach is look to the elements of what that new law violation is.
Well, what's the word conduct in there mean? Why didn't they just say which, it really...
It does appear that by using the word conduct and by the categorical approach, they're talking about two different things, I understand. But this court has always used the categorical approach when analyzing.
And I think the Supreme Court's decision in Davis may cut me off anyway on my inquiry. So let me let you go ahead and make your arguments. I'm satisfied at this point that we have to look at the categorical approach of the crimes being advanced.
Well, just briefly, Your Honor, getting back to the Green case, which is State v. Green, when the court said that orchestrating the phone call itself was the overt act. I mean, you could have that here in this particular case when the defendant contacted the person to arrange the meeting. That could be the overt act, and that in and of itself does not present an offense with a serious potential risk of physical injury to another. It's just too attenuated. And in the Nesbitt case, the South Carolina courts have said it is not necessary to subject victims to a face-to-face confrontation with somebody with a deadly weapon.
So how do we deal with that? I mean, your point's well taken on that. There are reported cases that might very well be, situations that involve the commission of this crime that aren't, by their nature violent. But, in a force clause sort of analysis, that would be problematic. But here I think, don't look at whether that can exist in that way, but you look at how the crime is ordinarily committed in the ordinary case. And am I missing that? Am I wrong in looking at it that way?
Well, I think if you look at this court's case in Carthorne,
Right.
which was an assault and battery on a police officer case,
Right.
I'll go out on a limb and say maybe that happens with more than just slight touching, and maybe that happens with in some cases with spitting in the faces. But sometimes it might be violent, but the court looked at the way the statute can be violated in sort of the least offensive way to determine what the risk was.
That's, I mean, maybe you could argue result-wise, Cawthorn does that. But the test that it articulates, that I think has been articulated in James and others, is the ordinary case, not whether there's a specific way or a least violent way.
Well, I take the position before this court that the ordinary case would be by the elements, and that we have an actual reported case that shows how the South Carolina Supreme Court determines what the overt act elements are, and that's what you use.
Okay.
Thank you.
All right, thank you. We'll have you back. All right, Mr. Cardinale.
May it please the court, Kate Cardinelli on behalf of the United States. This court should affirm the district court because the court correctly determined that supervised release violation was a grade A violation. And even if the court was incorrect in that determination, it was not plainly unreasonable. And even if this court held that there was an error, it was plainly unreasonable, it still should be affirmed because it was a harmless error, if an error at all. Turning to the first point, the district court correctly concluded this was a grade A violation. We are arguing under the residual clause, as has been discussed, because South Carolina attempted armed robbery falls within the residual clause because in its ordinary case, its elements include conduct that present a serious potential risk of physical injury to another. I want to address some of the points made for my friend on the other side's argument, specifically related to the overt act requirement. The cases of Nesbitt and the case that it cites, Quick, actually do limit, have a limitation on this overt act. It needs to be, there must be an actual or present ability to complete the crime. And in Nesbitt, the court actually found that there needed to be an attempt to gain entrance. So in Nesbitt, it was a attempted burglary of a store. And the court, in trying to figure out if this was a overt act, looked to 3 different cases. And the 2 cases that it found were similar were all cases where there either was an attempt to open the door of the place or was an attempt to gain entrance to the store.
Well, in this case, I gather there must be a distinction in South Carolina law between robbery and armed robbery. Does the statute define what armed means?
The statute defines South Carolina armed robbery is a person who attempts to commit robbery while armed and with a deadly weapon or representing that they have a deadly weapon.
It's a deadly weapon requirement then?
Yes.
So in this case, that would eliminate the hypothetical that your colleague presented where you just make the arrangement because we have to have the presence of a gun in order to have completion of the offense, even though it's just attempted. That distinguishes attempted armed robbery from attempted robbery. And so the presence of a gun, a deadly weapon, I guess it is, it's not the gun, and a step trying to carry it out presents that high risk of personal injury. I gather that's got to be your point.
And to clarify, the South Carolina statute, you need to be armed with a deadly weapon or represent that you are armed with a deadly weapon, and the individual must reasonably believe that you have it. I don't know if that you actually have to have a deadly weapon in that case, but I think the point is still that the conduct, the overt act, it has to be more than the hypothetical in the appellant's brief is being in the car. And I think the cases, Nesbitt, that's not enough. An overt act requires something more than that for South Carolina's attempted armed robbery. And so I think that the ordinary case, which was discussed, is the proper way to look at this case. And here, South Carolina attempted armed robbery does present a serious potential risk of physical injury to another.
Do we have to get into the ordinary case analysis if we think we can look at the application note and apply it here? Is that its own independent route to determining that attempt would be included?
I think it can be its own route to get there. I do think that this court doesn't need to get to the commentary, to the application note. I think it's clear, looking at James, looking at the ordinary case approach, that South Carolina attempted armed robbery fits squarely within the residual clause. And so I don't actually think this court even needs to get to the commentary.
So you agree with Judge Quattlebaum's suggestion that there might be 3 different routes to get there. One would be just saying this comes within the residual clause because the residual clause is so kind of broadly written. Another is reliance on the commentary on the application note. And a third is kind of the traditional ordinary case assessment.
So I think that I at least see two, and so I may
Ordinary
just
case
be.
is the first one, that the
That's how
residual
I
clause
see
is
it.
broad enough.
Yes, Your Honor, there are two different ways, but I think maybe the clearest and most simplest way is to go to the ordinary case approach used in James in finding that South Carolina attempted armed robbery.
What about our Doctor case and our Mack case? Do they essentially, by precedent alone, drive us to the conclusion that it's a crime of violence?
I think you can use them, as you mentioned earlier, of getting to the kind of the second approach, the getting through the commentary approach. I'm not sure it's completely foreclosed through those two cases. I know there have been a series of cases since then, and that's why I think the most straightforward way is through James and the ordinary case approach. And I'd like to raise the Cawthorn case, which was raised a little bit earlier. In that case, it is distinguishable from here. I think as Judge Quattlebaum noted, we're not looking for kind of the specific case where you might be able to commit the offense and not have physical violence involved. But in Cawthorn, they were really concerned with this prescribing a very broad range of conduct. And they explicitly distinguished James and Sykes, which James was the burglary case, and then the Sykes case as well. And so I think this case can also be distinguished. I think it's much more closer to James. I think we also have the closest analog being burglary. I think the face-to-face confrontation risk is here, as it was in James. And I don't think, in James, there wasn't a requirement. The burglary didn't require a face-to-face confrontation. The court was just concerned with the risk of that confrontation happening. And I think that's similar here. Your Honor, if there's no further questions on that first point, I'd like to turn to our alternative arguments. The first one being that even if this court were to find an error, it was not plainly unreasonable. In order to be plainly unreasonable, this court has to have determined there must be it must clearly contravene settled law. And here, this court has not determined whether South Carolina attempted armed robbery is a crime of violence under the residual clause. So the government's position is that it's not clearly settled law. I think in the appellant's brief that they concede that the federal classification of robbery offenses as crimes of violence have been in a state of flux, where they point the difference being is for attempt crimes, because South Carolina has had this overt act requirement for a long time. I would posit that is kind of a distinction without a difference. I think in general, these crimes of violence, the categorical approach has presented quite a challenge for courts, and it has been quite a state of flux. And an example of attempt crimes, this was the Taylor case last summer, still in a state of, showing that this has been in a state of flux. Your Honors, even if you were to find that there was an error and it was plainly unreasonable, any error would be harmless, because this court can say with fair assurance that the district court would have imposed the same sentence anyways, and either way. And so I think there are a couple things.
Did the district court announce an alternative variant sentence?
The court announced, no, it didn't. No, it didn't specifically address a separate sentence.
And did the court explain and justify the sentence kind of regardless of the recommended range? Did the court say, kind of regardless of the range, here's why I think this is an appropriate sentence?
I don't think the court used that specific language. I don't think it specifically said or found, even if this was a grade B violation, then I would have found this anyways with the guidelines being different. But that's not the requirement for harmlessness, and I think the court can look to four things to be assured that the court would have found this guideline range appropriate, even if, or found that this sentence was appropriate even if the guideline range was lower. I think the first is just that pointing out that the court found this to be a very serious matter. A firearm was used, and it was a significant breach of trust. And because of that, the second point here is that the court found 28 months as to both underlying counts. One of the underlying counts was the Hobbs Act robbery, where the guideline range was 12 to 18 months, and the court went above that, went 10 months above that to 28, and I think this court can look at that and say the court was willing to go above the guideline range to get to this 28 months. I also think it's
But the
important.
range on both of them would have been 4 to 10 months if you were correct that there was an error, right?
Yes, that is correct. So it would have been 4 to 10 months on each. And the court imposed these concurrently. It's not that far off from imposing a 14-month on each and having it consecutive instead of concurrent would get you to the 28.
Pretty speculative, isn't it?
I think we can look to, I think taken together, this court can look and see that the 28 months was important for the district court. I think on top of that, another reason why you can see that is the sentencing hearing, the discussion, the big issue was whether or not Hobbs Act robbery was a predicate to 924C. That's where a lot of the argument was spent below. And if there was question in the district court's mind as to whether or not that would be be overturned or for whatever reasons not be valid, then having both be 28 months would ensure that it could still go forward, that sentence would still be upheld. So I think these are just areas and ways that this court can say, taken together, that the court can say with fair assurance that this would have been.
Counsel, could I go back to your first argument? And this isn't to really debate the James ordinary case analysis, but you seem to kind of be pushing us that way as opposed to the application notes and our precedent. And is there a reason you're pushing us that way that you care to tell me about other than just your legal strategy you think is best, or is there some other reason you think we ought to go that route if we think the other route was also viable?
I think it's just the clearest on the cases and most straightforward, and that's why I am pushing that this morning. And if there are no further questions, just briefly conclude that we'd ask this court to affirm the lower court for the reasons mentioned today and in our brief.
All right. Thank you very much. Mr. Nuttles.
Very briefly, and I'll take this in reverse order, in regard to Judge Rushing's questions, my friend on the other side, there is no indication that this judge would have given the same sentence had the guidelines been 4 to 10 months. And the fact that there are two 28-month sentences should not be read as anything other than it's just one 28-month sentence. They're run concurrently, and the fact that and they will both expire at the same time, the BOP treats them the same. In regard to Judge Niemeyer's hypothetical, so the offense of attempted armed robbery only requires the specific intent to commit an armed robbery and an overt act in furtherance. So if one has the specific intent, one has acquired all of the items necessary to do the offense and then commit an overt act, one has committed the offense. It's not necessary for somebody to point a gun at anybody, to be in the proximity of anybody, and the Nesbitt court was quick to say that. And I just wanted to, if there are no other questions, I have nothing further.
Okay, thank you. We'll come down and greet counsel and then proceed on to our last case. All right, the next case we'll hear this morning is Tepes versus Garland. And Mr. Ritchie, whenever you get yourself ready, we'll hear from you.
Good morning. May it please the court, my name is Ronald D. Ritchie, and I am the counsel for the petitioner, Mr. Trejo. Due to the egregious errors of the government in this case, especially the immigration judge, this case, it's mandated this case should be reversed or at the very least remanded back, so that the record can be fully developed as required by this court in the Quintero case. And alternatively, or additionally, so that the petitioner can be given his constitutional and statutorily mandated rights to have his asylum application considered by USCIS, where it has been pending without an interview since May 2nd, 2018. It's really significant in this case that petitioner Trejo, just like the petitioner in the Quintero case, was pro se. But there's an additional element here of significance, and that's that the petitioner in this case was also an unaccompanied minor child, known as a UAC, when he was before the judge. He's entitled to certain legal safeguards. And, I'll go more right to the Quintero argument and come back to the other, but the judge miserably failed to, in her conducting the removal proceedings, to fully develop the record as she is required by statute. Inter alia.
The Quintero case has to be read with a little bit of common sense. And in this case, the immigration judge asked Mr. Tepes questions about that surrounded his circumstances, mainly his connection with the gangs. And after asking several questions in that area, it didn't seem like it's productive to go any further. What could you put in? In other words, we can't construe Quinteros to say you have to catalog or canvass all of the defenses that are available and find facts for the non-citizen. It basically means you have to be solicitous and helpful and not be over technical in all of that. But his testimony was pretty straightforward, and it didn't seem to suggest that anything further was needed. I don't know what you would like to have him inquired about or what was available to the IJ at that point.
Yes, Your Honor. Well, Quintero lays out, based on my reading and analysis, at least 6 requirements, at the very least, that an immigration judge must.
Well, let's at this moment. I know that case. Let's stick with the facts of this case. And what would you have expected the IJ to do in this case in light of what Mr. Tepes was relating?
Well, in this case, Your Honor, the IJ only asked 3 or 4 questions relating to the merits of the asylum claim. 3 or 4 questions.
Yeah, I understand, and I've read those questions. I've read the answers, and it sounds to me that his answers precluded any fruitful further inquiry in those areas.
Well, with all due respect, Your Honor, I would disagree because based on his answers, the judge should have inquired, okay, you put in your asylum application that you're not a member of that gang. One reasonable question would be, well, did you belong to any gang? Another reasonable question that the IJ should have required minimally was, well, you state that your classmates were killed by gang members, okay, and, you know, were you around when they were killed? Okay, where were you at when they were killed?
He answered that. He says it was nearby, but he wasn't connected with that. He wasn't threatened by the gang. He wasn't a member of the gang. No family or friends were members of the gang or threatened by the gang.
Well, Your Honor, I
You
don't,
don't want to have him lie, do you?
definitely not, Your Honor. But he wasn't asked, he's a young boy with a 9th grade education, doesn't have a lawyer. The judge, IJ, should have asked a lot more questions. The judge should have been more thorough and comprehensive, should have asked him, well, you know, how.
Would it have helped if you, when you got into the case, interviewed him and proffered what he would have said with further inquiries? We don't have that either.
Right, I just got involved at this level, Your Honor. But,
Well, I understand, yeah.
I think if he
I'm
had.
not faulting
Sure.
you.
If he had counsel, he probably would have done better. He would have fared better according to the statistics. And I think it's mentioned the statistics in the Quintero case. A person that has, an asylum applicant that has a counsel fares much better than one without.
But doesn't, I mean, Quintero has it acknowledges that we apply a harmlessness review, and it does set up a presumption of prejudice if the record's not sufficiently developed, there could have been more, but even that can be overcome. So we can't just look at the record and say, well, the IJ could have asked more questions or could have given more information about, you know, the technicalities of what a PSG is and how to define it. We have to look at this record and see whether, if all of that had been done, there's any reason to think that things would be different. And here we do have a record, and the applicant says neither he nor family, close friends, or colleagues ever experienced harm, mistreatment, or threats in the past from anyone. That's in his asylum application. And then at the hearing, he said neither he nor anyone in his family ever had a direct encounter with a gang member. So with that record, how do you overcome, how do you show prejudice?
Well, because we don't have the complete record, or we don't have that's probably misphrased, we don't have a fully developed record. Had the judge fully developed the record and followed, you know.
But doesn't the record you have seem to pretty much foreclose the possibility of harm on a protected ground?
Well, I don't know that we can come to that conclusion, because the judge is required to do at least 6 requirements at the minimum, and the judge didn't do any of those 6. Okay, judge is supposed to explain the
So, counsel, yeah, I think we appreciate the argument that some of the things that are listed in Quintero weren't done, maybe all of. So, I mean, that, and if the issue is, did it strictly comply with Quintero, that would be one thing. But what's your position to, I think the question both Judge Niemeyer and Judge Rushing are talking about, do you concede that if there is a record that forecloses the possibility of relief under a particular social group application, that you still we're still required to grant the petition and remand to go through those 6 questions if the record, I'm not asking you to agree that this is that record, but if the record makes it clear that you can't have relief under the particular social group claim?
Well, I would answer it this way, and the whole problem in this case is we don't know. The judge never got to that point, okay? The judge never developed the record sufficiently to know if there's no relief available.
I got you. So that seems to say, I mean, I think if I interpret your answer to be, because that's, that you can never, I mean, this is like a strict liability, do this or we vacate, because until we do it, we don't know for sure, regardless of what we do know. Is that your position?
That would be our position, Your Honor, and even if there's not a strict liability standard, there's minimal requirements according to Quintero and the statute and the Constitution that have to be adhered to. They didn't happen here. There's only 3 or 4 questions.
In another area of the law involving ineffective assistance of counsel, we're often confronted with situations where counsel didn't do what they should have done. Your argument here is the IJ didn't do what he should have done. But whenever we look at it in connection with the insufficiency of the representation, we always look to whether change things or prejudice the arrangement. And here we have no evidence that it would have, because the affirmative evidence that he gave seems to preclude it. Now, your argument is, I suppose there's some factual scenario that could have changed things, but then that's my follow-up question is, what is that? And nobody has made a proffer on that to show what I would call, I don't know if it's a requirement of it, but it would call prejudice for failing to follow the Quintero criteria. How do we address that? I mean, we're sort of in the area of abstractions.
Well, I think we can only get to there if we look at the requirements laid out in Quintero. If a judge meets those requirements, minimal requirements, then we can fairly and reasonably and legally state, okay, there is no claim here, or no claim that would support granting of relief. But the judge never got there. The judge never got past first base. Okay. The judge should have asked questions based on both what was in the asylum application and based on what the petitioner was asked and answered. Should have asked questions. Well, did any of your family members ever have any problems with the gangs? Were they ever involved with the gangs? Okay. That was never asked.
Answered that.
I'm sorry?
I thought he answered that question.
I thought it was only in the I-589, Your Honor, but I could be mistaken. Because, there were only like 3 or 4 questions. Yeah. And the judge spent most of her time asking about his schooling and education and not focusing on what the requirements are. If she had at the very minimal explained to the petitioner what the requirements are for the law and what he needs to show, and that his father could testify and different things like that, we would be in a different situation, Your Honor. I'll reserve, well, I have some reserves, so I'll go and sit down for now.
Thank you, Mr. Ritchie. Mr. O'Malley?
May it please the court, my name is Andrew O'Malley. I represent the Attorney General of the United States. The court should deny the petition for review because the immigration judge fulfilled her obligation to develop the record, and substantial evidence supports the ultimate determination that Mr. Trejo failed to establish eligibility for asylum, withholding of removal, and protection under the Convention Against Torture. And one of the touchstone principles that we can derive from Quintero is that what is required of the immigration judge is really dependent on the facts and circumstances of the case.
Is that really right? I mean, I get the, prejudice argument, and I think, I'm not sure what that we need to think about that. But, I mean, doesn't Quintero pretty much say, I mean, whether you agree with that or not, that's our precedent, and it says, at a minimum, you must do these things. It doesn't say in certain factual situations you must do these things. And it seems to me the only thing we have as a, potential out on that is near the end where it says it's presumptively prejudicial unless the error is plainly irrelevant to or otherwise does not hinder in any way the reviewing court's ability to assess whether prejudice occurred.
I agree with you on the prejudice point, Your Honor. And
But you started off saying it's this, kind of, look at the facts and then decide whether to apply, do this or that to develop the record.
I believe that's a fair reading. I don't think it's a matter of developing the record. I think it's, you look at the facts, you look at what the claim is, what the facts and circumstances of the fear are, and then you determine, is that a basis for relief as a particular social group? And if that's the case, then you can work with the individual to develop the contours of that definition. And as we know from all our particular social group cases, the specific delineation, the specific definition is absolutely key. And that's where the immigration judge needs to delve into helping the pro se applicant define the specific contours of that particular social group. But where, as here, there is no basis for a particular social group evident in any of the testimony or the record, there's really no reason to go in and start developing a specific definition. That wasn't the case in Quintero, where the individual was a former gang member, was threatened, was beaten, was harmed, could not leave the gang. Those are facts on which you can build and define what you need, which is an exact delineation of that particular social group in order to apply that nexus requirement. And that's what I think is the key in Quintero, is that where the facts present where there might be a potential social group, then the immigration judge has the responsibility to go through and define.
Where's the
That's not
language in
case here.
Quintero that you're saying tells us there needs to be some indication that there's a viable particular social group before you must do what Quintero says?
We have everything depends on the particular facts of the case. I'm sorry, let me see. Well, here we go. Thus, we find that petitioner alleged sufficient facts relevant to his eligibility for relief during his removal proceedings to put the immigration judge on notice as to his potential social groups.
Well, can you,
I'm sorry.
Can you give me just a page or something? I don't know, a reference point for that?
Yes, Your Honor, that's page 640
Okay, thank
under
you.
subheading F.
All right.
And I think if you go through the entire decision, that's sort of key to the whole thing, is that you've alleged sufficient facts that the immigration judge needs to go and define the contours of that group. That's not here. And there really was nothing for the immigration judge to do because there's no facts on which to define a particular social group. It would have been make work to sort of sit down and define the contours of a group that simply can't exist. And again, Your Honor, I think this is on the facts. It's highly distinguishable from Quintero, where there were so many facts on which to define a particular social group. Now, petitioner speculates as to what Mr. Trejo might have said if the immigration judge asked particular questions, specifically about the classmates that were nearby. Of course, we have nothing saying that anything would have come out of that questioning. He's never said, I witnessed that, or those classmates were my friends and I was afraid I was going to be in the same group. He has never said that.
But we've been talking a little bit about this. What do we do with the absence of a record? And should there have been a proffer, or, we don't have the evidence? I was kind of under the impression that Quintero seems to resolve that uncertainty by saying there's a presumption of prejudice because we can't know what was not developed, especially when someone was pro se. So there's this presumption of prejudice that can be overcome in certain circumstances. Is that an accurate understanding of how Quintero wants us to fill the void?
I'm not sure that that's a fair assessment of how proceedings should go on. Because
That might be right, but is it what Quintero says?
It does seem to say that, yes, but at some point, if there's no reason to send the case back for development of the record, then why do it?
Well, so you're pointing out, you might have a record that shows that wouldn't be fruitful, right? Like here there wasn't any discussion about the group because the petitioner said, I have not been harmed, basically,
That's
right? There's no harm, so there's no reason to look at, am I part of a group that was targeted for harm. And
That's right.
for a particular reason. Like, the reason doesn't matter because there was no harm.
That's exactly right.
But I'm not sure that the questions about, I'm not sure it's left to us to decide how is the void supposed to be filled. It seems like Quintero tells us we presume prejudice, but in certain circumstances you can overcome it. And the question for us is, has it been overcome here?
I think that's fair, and yes, I think it has been overcome here because there's no indication that he would have ever said anything else. And I think
But that it's kind of circular, right? I mean, so it would seem to, I mean, look, and I may disagree based on what we know. It seems hard to imagine what the particular social group would be. But to follow up just what you in the dialogue with Judge Rushing, I mean, maybe if he's not harmed, yeah, because as I recall, you know, the immigration judge, you know, kind of acknowledged, hey, you're not going to be able to understand what a particular social group is, which, quite frankly, is a bit troubling. And Quintero would say that's the whole point. You're supposed to make sure they understand that. And now, if there's a clear, applicable particular social group that just wasn't articulated, and there's not any harm, yeah, maybe that issue becomes kind of irrelevant. But it seems hard for me to look at Quintero and say, at least in terms of the particular social group, you know, the immigration judge has a duty to explain it and talk about the different types of social groups. And maybe we got a situation here that's not necessary if there's no harm, regardless of how perfectly you articulate a social group.
I think that's a fair characterization. I think that's what I'm trying to say in terms of when you look at the facts that were developed to determine whether or not there's a basis for a claim, there's no reason to get into whether or not the delineation of a particular social group and trying to explain to petitioner a particular social group requires, you know, social visibility and
But the presumed prejudice in Quintero arose out of the discussion that started with the facts suggesting a further inquiry, and the court spent some time on those facts that had provoked the further inquiry, and said he'd been a member, that he would be killed if he left, that his cousin was killed. The immigration judge, why would he kill him? He explained the gang had already threatened him along with his cousin, and that MS-13 had murdered Romero for leaving the gang. And the question was, in those circumstances, what is the appropriate articulation of a group? And the court said that circumstance is presumed to be prejudicial. It's a little difficult to fully understand what we're to do in this kind of circumstance, because the argument could be made that if he simply didn't conduct the inquiry, it's presumed prejudicial and we tell him to conduct it. But in this case, we don't have the facts that suggest the inquiry as Romero did.
I'm sorry, are you saying you don't have the facts that suggest the inquiry is necessary, or the facts that?
Yes, yeah, in other words, it's, that Romero seems to imply that you just don't do this in a vacuum, that the facts should suggest to you that you do something more. In that case, there were quite a few facts about his leaving the gang and being threatened and killed, and his cousins being killed, and all this type of stuff.
That's
And that there was a practice of MS-13 to kill people who weren't members. And so the only difficulty was the petitioner didn't have the ability to develop, in that circumstance, what is the social group? And I don't know how that plays out fully, because I think there's other language that say that we have this presumed prejudice if he doesn't make that inquiry. But maybe we have to read into that if he doesn't make that inquiry in the context of those facts.
I think
or facts of a similar nature.
I think that's absolutely right, Your Honor. Where the facts.
Well, I'm raising this question.
Oh, you're raising it as a question.
That should be right, but there's a fair argument, I think, Judge, that, I mean, we certainly do have those facts that, may have informed the decision there. Whether the holding in the case, requires that, I think is, maybe not your strongest argument. I think your strongest argument might be, look, accept the fact that you were supposed to do it. except the fact that it, that there may be even, had you done so, you might have identified a particular social group. But even if you have the perfect one that's well-established and undeniable, you still have to have a threat and you still have to have harm. You have to have some level of persecution. I think that's probably the best argument you have.
Okay, not conceding the first point, but yes, and I think the facts that he established or that he pled to are, they put him in no different position than anybody else in El Salvador, and that's just not a basis for relief. I'd also like to point out that he was 20 years old at the time that he testified. He was over 18 when he filed his application, so he was not a child testifying in court. He also filled out his application with the assistance of Catholic Charities, and that application provides absolutely no details with respect to any sort of claim. It was that simple. I'm afraid of gangs because I wasn't part of their group. He provided no more testimony to flesh that out in immigration court. I would also point out that the viewing of that comment that, well, I had classmates killed nearby, and whether or not that warrants any more sort of inquiry or discussion, at some point that has to be left to the discretion of the immigration judge, who's the frontline adjudicator, who's in the room with the applicant, who can see how this claim plays out and who sees these kind of claims all of the time. So to look at a cold record and say that absolutely warrants more inquiry is a little difficult to do. I'd also like to point out that the voluntary departure issue, petitioner raises that the applicant wasn't advised of his right to voluntary departure. Petitioner has waived any argument on the merits of that and only addresses the alternative determination that it was waived on appeal. Ultimately, that doesn't matter. This individual was an applicant for admission. He's simply statutorily ineligible for voluntary departure. So that issue is taken care of in that matter. I'm happy to address the jurisdictional issue with respect to the JOP litigation. It wasn't exhausted, the argument that petitioner is trying to make. The immigration court, for the reasons that we cite in our brief, properly exercised jurisdiction here. And I think that's clear by statute and case law. Unless there are further questions, Your Honor, I'll yield my time back. Thank you.
O'Malley. Mr. Ritchie?
Thank you. First, I want to note that as Your Honor, Judge Niemeyer, I point out that yes, I apologize. The judge did ask the petitioner if the MS or 18th gang, had any encounters bothered anyone in your family. I answered that. I was thinking about on the I-589.
You allowed for that.
Thank
Fair
you.
enough, thanks.
One mistake, okay. Well, I would just about the harm, the prejudice, I believe there is prejudice and harm. I think there's two elements to that. One is in the asylum, one has to demonstrate either past persecution or a well-founded fear of future persecution. And I don't think the judge could have and should have gotten into that. But I would not concede that he hasn't suffered any harm. He said he feared for his life because he's witnessed his classmates, school classmates, young kids getting killed by the gangs.
Have we ever held that fear of harm? Let's assume you've never been harmed physically. You've never been threatened. Have we ever held that in the absence of actual physical harm and actual threats that, there has been persecution for purposes of asylum?
Well, I mean, the cases in the statute states that you can still prevail on asylum even if you haven't suffered any threats in the past, death threats in the past, or physical harm. If you have a well-founded fear of future persecution, you can still prevail.
And maybe just tell me a case where there has been a holding of a well-founded fear of future persecution, where there's not been any past physical harm or past threats. There may be one. I don't recall one off the top of my head. Are you aware of one?
I am, but I couldn't give you any cites, Your Honor.
That's okay, I understand.
But I would state that he did suffer harm as I said, he didn't suffer physical harm, but he suffered mental and psychological harm. It caused him to stop going to school. It caused him to flee the country because
I just want to circle back to, you said he testified that he witnessed his classmates being murdered. That's not what I recall. I thought he recalled that he had classmates who had been murdered. But I don't recall the witnessing part of that, but you might be able to point me to where I missed it.
Well, I guess that's part of the problem here. He stated, the judge asked him, did gang members ever approach you directly? His answer, quote, yes, nearby, near, close by, because they killed classmates. So, and then the judge was asked to follow up on that, and he kind of answered in a kind of a different way. He really didn't answer. And so the judge then realizing, the judge should have realized, okay, we got something here possibly. Let's find out what's here. Let's explore this. Let's follow up. Well, what do you mean you know that classmates were killed? Where were you when that happened? What, did you witness it? So there's an implication there that he did witness it.
I thought the follow-up was, did you have a direct encounter with a gang member ever? And the answer was no.
Right. That is, Your Honor. But that doesn't foreclose that he didn't, witness from even a short distance or long distance his classmates being killed by gang members. That question is vague. Okay, encounter. Well, for again, ninth grade education, young boy without counsel, he could have interpreted that in many different ways. And that's, again, part of this whole problem here. There is harm, there is prejudice, because it wasn't fully developed. The judge should have followed up, at the minimum, questions about, well, okay, you say that your classmates were killed. When, where, and what was your proximity to all that? Were you close by? Were you in the area? And that was never asked. That's why why this court laid out, these requirements, safeguards for pro se applicants. It's to protect individuals like this petitioner from suffering the prejudice of not having his record fully developed, not being explained what a particular social group is in plain language, which a Quintero requires, not trying to...
I can't figure out what the social group is, and I guess you can't either on these facts. Whereas Quintero, the facts were all the facts there were basically necessary. The guy was in a gang. He tried to leave the gang. He was threatened. He was threatened with killing. His cousin was in the gang, was threatened with leaving the gang. He was, in fact, killed. That leads to the question, okay, there's a threat of harm. You've suffered a risk of persecution. At that point, it calls, well, you don't know how to frame the social group, but I suspect that your social group is this. And he says, yes, that's fine. But in this case, I know that some of the language of Quintero supports some mechanical application, but I'm not sure I take it that way. I think the court, we reacted in Quintero to a circumstance where the non-citizen was basically laid out a really potential claim, and it was simply denied because it wasn't developed adequately, that claim. But in this case, it's hard to find whether this is an asylum claim at all.
Well, Your Honor, understand that the facts are different in their underlying claim. I just have like 2 seconds if I can just go on for about 30 seconds.
Sure.
We do lay out what we believe are appropriate particular social groups at page 18 of the petitioner's brief. Basically, membership in a PSC of an El Salvadorian classmate of youth killed by violent and powerful gang members. Another one, El Salvadorian witness to school classmates killed by violent and powerful gang members. But the judge never got into any of that. It should have been clear from the petitioner's statements, his testimony, that area is out there to be explored. And the judge just like, no, let's move on to school.
What if we think those particular social groups as a matter of law aren't valid?
Then it doesn't change really what should happen, because, again, this case is all about, did the IJ follow the provisions, the requirements as laid out in Quintero? The
So
judge
you don't
did
even
not.
have to, in challenging this, articulate a potentially viable particular social group that would, and I know you think you have, and maybe you have, I'm just saying hypothetically. If you don't articulate even a viable particular social group that could possibly apply, do we have to grant the petition under Quintero?
Well, I think at the very least, it should be remanded back to have that developed to see, okay, what
That
particular
sounds like
social groups.
yes. It sounds like your answer is yes, that even if in the challenge, there's no, once counseled articulation of a viable particular social group, we still need to send it back?
Well, yes, because we don't have all the facts. There are other cognizable PSCs may arise once we have all the facts.
Okay.
Thank you very much.
Thank you very much. We'll adjourn court for the day, come down and greet counsel.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.